Oh, Chair, sorry, I was saying, yeah, this is unusual.
Can I assist you, Advocate Mpofu?
Yes, please.
There is sometimes multiple of the same emails and they in a train. And so if you might find the same email in the middle. So you might have the same one, but not done differently, if you know what I'm saying.
Yeah. No,
So it could be the same thing, but it's just, so I know in the documents, the same email might appear 10 times. And
yeah.
I may have referred him, or you may be using a different version of it to before.
All right, fine. Okay, let's do it like this then, because this is for the benefit of the members, so that they can find it when they are looking for it, not me. So we'll use the one on the screen. So that email trail, basically, this is an email from the PP that says, legal services can get a legal opinion from SC about this matter. They now blame PPSA for not reporting receipt of the report and violating the Protection of Information Act. That's from the PP, correct?
That is correct.
All right. Now, on my configuration, that is...
Sorry, Chair, through you.
Yes.
You're wanting to go to the SC reference that the witness, that I took the witness to. That's not this email.
No. I'll go there. I wanted to start here. I know where that one is. We'll go to it. All right. I'm just wanting to show that the reference to SC here in this thing. Legal services, can you get a legal opinion from SC? And then can you roll it up a little bit? Mine is 5818, but let's use yours as 5820. Roll it up to the other email on top from Mr. Nyembe. It starts with good day, Advocates Kakan. No, it will be, I think it will be before this one. Yeah. Oh, I don't know what's happening. 5818. Okay, then we're on the same page, literally. Okay, yeah, thank you. All right, okay, now we're on the same page here. Yeah. All right. Then I'm just, okay, you said you didn't know at that time, but I'm just saying if you were emailed. Yes, you were copied on the earlier one, the one that says can get a legal opinion from SC. This was at 4:30. And then this one is about an hour later. It says, good day, Advocate Kakane, and so on. And I know you are not copied on that one, but was there any other SC that was involved in this matter other than Advocate Kakane, to your knowledge?
He hasn't said that they had knowledge of Advocate Sikakana being involved in the matter.
Okay, right. Just, yeah, you were quick because I have not recognized you. Now you're having a direct interaction.
Sorry,
with
no, that's fine.
both.
That's fine. I understand. She's
okay.
right. Yeah. Oh, okay.
Thank you.
All right. All right. Maybe let me put it this way. Okay. From the two emails that I've shown you, the one which is legal opinion from SC, and then the one an hour later referring to Advocate Sikakane, the public protector will, when she testified, confirm that the only person that had been briefed on this was Advocate Sikakane, as it seems obvious. Did you have knowledge of any other SC involved, including Advocate Sikakane?
No, I wouldn't have known, because at this stage, that's where our legal services people interact and deal with the.
Right. No. Now I think I get it. So what you are saying is that in the earlier email where you are copied, And Mr. Namasisi is yeah, that's the one. Mr. Namasisi is copied, that's the head of legal. And then he's addressed directly. Legal services, can you get a legal opinion from SC about this matter? For you, you did, that was not being addressed to you specifically, and you did not know who that SC is. Maybe Mr. Namasisi did know. Am I right? Mr. Mataboge, have we lost you? I think we have lost him, Chair.
It's not there. Mr. Mataboge is not there. No? Okay. Just a few minutes pause with Mpofu and we'll get somebody to just call him so that he reconnects. It's just 2 minutes pause.
Thank you,
I
Chair.
don't know whoever put it there, but it's an investment.
Well, it's obvious, Chairperson. It was put by none other than Advocate Mkhwebane. That will be the first question I put to her when she comes to the stand. Who put the generator? That works so well. Chair, thank you, Chair. Right, I was saying, Mr. When we were disturbed, I was saying that I wanted just for you to confirm if my understanding is correct. The email that we looked at earlier says, legal services, can you get a legal opinion from SC about this matter? And I was checking whether from your answers, even though you were copied in that letter, and this particular instruction was directed at legal services, you did not know who they were talking about.
Yes, correct.
Obviously, between the sender, that is the public protector, and legal services, they knew who they were talking about, correct?
I believe so, Reverend Pofu.
Yes, and maybe just for completion, no, that's fine, I understand. I think then Ms. Bauer's correction of me was correct. If we go to 5816, at the bottom. Yeah, the middle sentence says, we are now in the process of checking the availability of the senior counsel. Again, that's not identified and you are copied. Again, you just knew that there must be some senior counsel, but you did not know the identity. Is that am I correct in that understanding?
That is correct. Yeah, that is correct, Reverend Pofu.
Right. And then just roll it up or down or whatever. Yeah. Then again, this is like 10, 15 minutes later or 30 minutes later, let's be generous. There's another email which says, thanks, Mr. Namasisi. Advocate Moses Kakane is available to meet at 11:30 tomorrow. Okay, so you are saying you didn't make that connection.
No, this one, if I was copied, then I would have started to make the connection because I'm copied here.
Yes. Yes, in fact, yes, you are copied in both. Okay, no, that's fine. I think it's obvious now. All right, then let's go to the one that Ms. Bauer did refer you to, and that was the exact point, that she did not refer you to that one. That makes it obvious who the SC is. But she referred you to a different one that makes it look like it's debatable. Okay, if you go to 6548, then this is the one you are referring to. You are referred to, Mr. or rather, yeah, you are, it's sent to you actually, you're not just copied, by the public protector. And she says, actually, we can discuss PG today. You can indicate the time in the afternoon. And the Busasa Thursday, I get a draft to share with SC before finalizing it if necessary. And then you said, I'm also in agreement with PP of sharing Busasa's draft with SC before we finalize it, perhaps even the rogue unit one, madam. And I think your evidence was that it was a question of sharing it. You knew that SC means senior counsel. Was there any reason to believe that now there was another SC suddenly meant somebody else?
No, there wouldn't have been any reason.
Okay. All right, thanks. Anyway, that's fine. Let's leave it there. The PP will explain all this. All right. Then right, I won't take you to it just to try and save time. You remember that exchange, I think it's at 5897. There was the exchange about where you were overwhelmed. This side, the PP wanted a report and a draft section 7.9. The other side, Ms. Baloyi wanted you to go to some meeting, and you indicated that you were caught between a rock and a hard place, I think was the heading of your email. Remember that?
I do what good.
Right. Now, I want to just say something about that, because the public protector has been portrayed as some monster and dictator and all sorts of things. My understanding of that conversation, and you'll correct me if I'm wrong, which you will find at 5897. Starts at 5896, and I'll paraphrase it to try and save time. Basically, you are invited to a meeting by Ms. Basani Baloyi, and then you try to say, may I be excused because the PP has got deadlines, 2 section 7.9s and the rogue unit and the Pillay appointment and all that. And then Ms. Baloyi basically tells you where to get off, to say you must just attend her meeting. I think she says, yeah, unfortunately, you have to attend the meeting as this is your matter. Your apology is not accepted, something like that. Remember that?
I do what good.
Okay, then you write to the CEO, this is the rock and hard place email, to say that you are now caught between instructions from different people, I suppose all of whom are senior to you, correct?
That is correct.
Right. And the public protector basically says, resolves the issue by saying, Rodney, this is at right at the top, yeah. Rodney, attend the COO meeting. I will get the 3 tasks as soon as you are done. Send me the drafts of the Pillay report, the section 7.9. In other words, she almost gives in to say, well, go to their meeting. I know you are now caught between a rock and a hard place, but you should rather go to prioritize them, as it were. And my question is really, is that the sign of a leader who's a dictator?
No, it's not. And then with how I felt at the time, I thought that you would protect me in that instance.
Yes, thanks. So you expected her to protect you, or to say, no, come to my meeting, I'm the public protector here.
Something like that, especially because if I may explain a bit, since the team I led, had to hold this complex cases reporting directly to PPP, or sometimes, we're being perceived as the, I wouldn't call it the blue-eyed boys or the blue-eyed team, but as the special team. And that would not augur well or sit well with some people in the office. So that is why now I was saying protection was somehow needed to direct me going forward, as well as my team. Yes.
And to be fair, you were handling very sensitive, what one might call special reports. Busasa, Rogue Unit, and Pillay were some of the more complex matters, correct?
That is correct.
So, as I say, so sorry, I'm sure she will apologize for disappointing you, but that's why you thought she would come to your rescue to say, and tell these other people where to get off.
Yes, because I knew their motive. They were just trying to say to me, you're under us and come here.
Yes. All right. Thank you. Thank you very much. Yeah. Okay, so oops. All right. That sorted, IT? Okay, thanks. Let me do this then, so that we then get out of this before tea time, get out of the rogue unit matter. I'm going to try and I'm going to propose some shortcut of how we deal with this. Otherwise, we have to go through the painful exercise like we did with Ms. Mkhwebane. Can I refer you to, I'll refer you to two pieces of evidence, which if I get to that, but if I don't, before tea, I'll refer you to one. If you go to 6072, yes. This is an affidavit. Okay, this is sent to you and Ms. Mukhaladi by the public protector on the 7th of December 2018, correct?
That is correct.
And it incorporates an affidavit which is too long, 135-page affidavit of Mr. Lucas Luther Libello, submitted to before the Commissioner, retired Judge Nugent. You remember that?
Yes, I do.
And I proposed to the members that if anyone wants to understand blow by blow the whole rogue Unix saga, apart from reading that 66-page document, that they should read this affidavit. Would you agree?
I would rather not comment on that.
Okay, let me put it this way. In your assessment of that affidavit, was it
Chief,
giving?
Can we ascertain? Sorry, Advocate.
Sorry.
Yes, Advocate Power.
I don't know that the witnesses testified that he read it.
Oh, okay, fair enough. This long affidavit, which was sent to you by the public protector, you read. Did you read it?
No, I gave it to the investigator, Ms. Mkhwebane.
Okay.
Not so much, yes.
All right. Okay, no, that's fine. She testified that she read it here. All right, no, that's fine. Anyway.
Sorry, Advocate Mpofu, that's not correct. She said she was not given it. That was the evidence.
Well, okay, the record will say whatever it says here. But okay, let me, then I'll take you through it now. Not all 135 pages of it, I can assure you. I'll just, I'll read out the topics, yeah. And then I'll ask you the question afterwards. That affidavit, the public protector definitely received it and she read it, and so it's going to come in, but that's in the future. But for what it's worth now, I'll just take you through it. If we can walk through it step fast. It says effectively paragraph 6. He says, on 27, 28 September, I appeared before the above commission, that would be the Nugent Commission, wherein I presented oral evidence. Subsequent thereto, I sought and obtained legal advice, and I was advised to submit further evidence by way of a sworn statement, which I did on 21 October 2018. when I appeared before the commission, in addition to such one statement on 21 October 2018, I also presented oral evidence. Then he says, I note with concern that the affidavit's presentations and any form of evidence presented by persons who appeared before the commission have been uploaded on the website. For whatever reason, my affidavit is still not uploaded, and so on. Okay. But he then goes on into the details which you would be familiar with. It talks about the terms of reference of that commission, I suppose. Then go to page 6086. 6086, paragraph 31. 31. Yeah, that one. Yeah, right there. Okay, I won't go into detail here. So here he deals with the Sikakane panel outcome and the appointment of Mr. Moyane. You are familiar with the Sikakane panel, Mr. Mataboge, and it was relevant to the rogue unit report, correct?
Yes, correct.
Then next one, he says clarity on different investigations and their roles. Sorry, that is paragraph 35. Then it deals with the Sikakane panel report, 36, paragraph 36. Deals with Martin Brassi investigation, 39. KPMG investigation, 42. Findings of Brassi, and so on. Those are some of the documents referred to in the so-called rogue unit report, correct?
That is correct.
Then go to paragraph 52. It deals in detail with Mr. Pillay, the unlawful and illegal establishment of the unit, also known as a rogue unit, right? Then it goes into the provisions of the, it goes into the Trevor Manuel memorandum. Just carry on, Tsepo. I'm just skimming through. Next one, where are we now? 1698. Yeah, it deals with the act. It is misrepresentation to the minister by Mr. Pillay. Just notably, paragraph 69. It says here, the unit's management, that is Mr. Pillay, Mr. van Lochenberg, Mr. Richa, Mr. Andries Janssen van Rensberg, and Mr. Johan de Waal have all worked in NIA before joining Equally without any tax experience. You see that?
I see it, yes.
Yeah. In other words, well, no, that's fine. We'll leave that to the public protector. Then it goes to the PFMA, covert spying on current and former SARS employees, engagement of informers, Project Sunday Evening. Am I moving too fast for you, Tsepo? Okay. I'm now at 6111. It deals with the facade disbandment of the unit. That's 100. Yeah. Then after that, the next heading, I'm just doing the headings here. Maladministration regarding the unlawful and irregular conduct of Mr. Pillay. Next one, purchase of unlawful and illegal covert spying equipment. Illegal and unlawful acquisition of for covert operations, equipment from the American Embassy, acquisition or purchasing or an attempt to purchase DNA tracker data processing equipment, Pillay resignation and this 18-month stint. Mr. Johan van Lochenberg is the next heading. And then talks about the existence of a prima facie case of misconduct against Mr. Johan van Lochenberg. That's 128. Yeah. And then allegation that the relationship between Mr. Lochenberg and Ms. Walter, the alleged girlfriend, created a conflict of interest. Next one, allegations pertaining to the unlawful disclosure of SARS confidential information. Next one, interference with Ms. Walter's tax affairs by Mr. van Lochenberg. Next one, this is a so-called a charity organization formed by Mr. van Lochenberg called Wachizungu Sawa Sawa, in which some monies were was investigating. No, sorry, let me not misrepresent. Says, I think it's 150. In other words, it would seem the companies and individuals from Mr. Lochenberg was investigating and even prosecuting donated to his charity organization, which is outright conflictual, if not illegal. In this regard, the employer and the Brassy panel had a view that by accepting the donations, Lochenberg placed himself in a position in which he may appear to be influenced and compromised. The SARS and the Brassy panel is in possession of a list of the donors. I think that was the allegation. Next one is the allegations that Lochenberg had disclosed information to the media on SARS affairs and shared SARS confidential information without authorization. Okay, and so it goes. I think it's just it's too long. It's 135 pages. I think from the headings that I've read to you, would you agree that this deals in depth with some of the issues that you had to deal with regarding the so-called rogue unit?
That is correct.
All right, that's fine. We'll leave it at that. Right. Then the last point is, oops, sorry. $5825. Oh no, sorry. Let's just go to 5825. Okay, you're not copied on this, so maybe you are not aware of it, but let me just I'll raise it anyway with you. Something that's it's dear Mr. Sianejo is from Mr. Namasisi, so it's a legal thing. And then he says, kindly confirm is you have probably that you have a letter and legal opinion from the council. Then please also advise senior counsel that Mr. Shivambu attach the report in question in the Equality Court. This means that the report in question is now a public document. Okay, so this is right. I was saying that this is a reference to the Equality Court matter, which Equality Court is just is in the High Court, but this particular one was in the High Court. It can also be in the Magistrate Court. This was a case before Judge Sutherland. And you may not know those kinds of details, but were you aware that the report had been discussed in the public domain as having been disclosed in some court papers?
No, I was not aware.
Okay. All right, then I'll just refer to it just for the sake of the members, but we'll deal with it when the public protector.
Chair, the witness says he's not
Okay.
aware of it, and no advocates office going to take him to it again. A judgment is a judgment.
Yeah, but so what? You read judgments for hours and hours here, and
As you did too. As
Yeah,
recently as yesterday.
okay.
so
The
that,
point is the
in that
witness
case,
doesn't
then it's
know
fine.
the judgment.
pardon?
The witness testified he wasn't aware of it.
Yeah, so
Is there going to be a question emanating from it of a
Yes,
judgment that he
I'm
doesn't
saying
know
I'm
about?
going to refer it to reference for the members so that when we come to it with the public protector, what's the problem? You don't want the truth to come out?
No, I'm looking at time, Advocate Mpofu.
No, don't worry. I've got until.
What is this?
Thank you, Advocate Mpofu. You have not been recognized.
Can you please recognize me, Chair?
You have not been recognized. You're going to raise your hand and then you are recognized. You've not been recognized and you're not going to do that.
Chair, please recognize me.
You're going to raise your hand and you're going to be recognized.
Chair, please recognize me. My hand is up.
Now your hand is up. I can recognize you. What is the point of order?
You must relax when I chair. Yes, you'll have palpitations for nothing. Chair, I'm saying Advocate Doe is extremely out of order.
What is the point of order? What palpitation are you talking about?
I'm saying you must listen. Learn to listen to present. Mamela, I'm saying to you, Advocate Bauer is extremely out of order, and I don't understand why you are allowing her to do this to Advocate Mpofu. When she was leading the evidence, no one interjected her, no one complained about her long speeches and everything else. You must allow Advocate Mpofu to go through this uninterrupted. Chair, why are we allowing it? Please.
Thank you, Honorable Mautwe. Your point of order is not sustained. I'm here as a chair and I was in the middle of this issue. Perhaps we can welcome you back to the inquiry, but the point of order is not sustained.
My apologies, Chair. I couldn't attend on Tuesday because you
I'll turn to this. I think
sorry, Chair.
you are done now. What are you doing?
I was saying I apologize for not attending on Tuesday because we had a media launch of our 10th anniversary of the EFF. That will take place 10th of July. So I apologize for not having informed.
No, I was not speaking about Tuesdays. Let's not go there, please, Honorable Mautwe. I was just welcoming you back to the inquiry. Thank you. For Advocate Mpofu's protection, I did indicate earlier that she needs to speak after being recognized, Advocate Bauer, but the two of you then got into this and I decided to just step back.
No, thank you, Chair. No, you're right. We were all.
And you seem to have managed yourself, both of you. So please.
Apologize.
Yeah.
No, it's fine. We were all out of order.
Please go ahead.
So, thanks, Chair. But it has resolved itself.
Sure.
Yeah. And just to make it clear, I was just referencing this for, as I say, for the witness has answered as he wants. So I was referencing it for later reference, the public protector. And I think we've clarified that. Okay, let's not waste more time on this. But bundle H, I don't know what page. Item 31, number 31.5.1.
Page 465, I'll help you.
Page 465. Thank you. Yeah. All right. That's the judgment. This was a matter between Pravin Chamnadas Godan and Julia Selomalema and Freedom of Expression Institute. It was to do with some alleged defamation of Mr. Godan, which, I won't repeat what was said there in case I'm accused of the same defamation. The point here is the only relevant thing for this commission is the reference to the IGI report, which was started paragraph 24. Right. It says that this stance, that's the stance about whether the report. Oh, by the way, interestingly, what was being suggested is that anyone who has attached the report or read it as threatened against the public protector, thereby was committing an offense. And I think one of the members said something to that effect, which would have meant that anybody who had read those court papers, including the judge, should have been taken to jail. But anyway, it says this stance provoked an application to strike out these inclusions on principally the grounds that they were irrelevant. The three inclusions were the report of the IGI of 31 October 2014, the IGI report, so that's our report, and the report on the Commission on the Cabal of 14 March 1990, that's a report from O.R. Tambo about the Cabal, the UDF Cabal. And then the Sekakane report. And then of these reports, the IGI report stood in a distinctive category in that it was a document admittedly classified secret that had been allegedly improperly leaked into the public domain. And then, okay, let's jump. To paragraph 29. Then the judge concludes as follows. A reading of the report and the minister's rationale for excluding it from the public domain reveal that the rationale is wholly unfounded. The burden of the minister's perspective is that agents of the security agencies may be compromised, which is interesting because if this is not an intelligence thing, then I don't know why agents may be compromised. But anyway, that's me. So no agents' identities are disclosed. The persons described are not secret operatives in the list. Moreover, at the time the document was attached to Shivambu's affidavit, the document was already in the public domain and had been the subject of media reports, and confidentiality claimed for the document is futile. And I'm just saying that whether you were aware or not of the particular judgment, this was the most secret document because it was out there, and the judge ruled as I explained this, but that will be dealt with by the public protector. But do you understand the thrust of what I'm saying?
Yes, I do, I do.
Thank you. All right. Now, I tell you, I don't know. Now I'm going to be as guilty as Ms. Bauer of staying with this rogue unit, even when I'm trying to get out of it. Let me do it like this just to save time. If you go to the report, I had intended to take you to the report itself and take you to the parts that Ms. Mviane had not confirmed. But I'll just do it in the broadest possible way. And I was just going to focus on one thing because we spoke with Mr. Mviana about the establishment, the operations, the intelligence, the jammers and all that. So I was going to just take you to the specific issue of the HR, let's call it a recruitment issue, just so that we don't cover the same ground. So can we go very quickly to 6498, Tsepo. And this is, I'm just referring you to one of your drafts, I think, and the reason for that will be clear. 6498. Now I know that you are not the principal drafter, but these drafts would have gone through your hands at some point or another, correct?
Correct, Edwin Bogu.
All right. Now, I'm really just going to do this very quickly because I want to move to Pillay now. So let's just take that. As I've said here, the findings were many, but even one of them would have been enough. Yeah. Let's quickly go to 6498. All right. If you remember this has to do with the issue of regarding whether SARS failed to follow proper recruitment processes in appointing employees who worked for the intelligence unit, and if so, whether such conduct constitutes maladministration. I'm just going to try and demonstrate cryptically some of the information I would have gone through with you in detail. Are you aware of 5.4.4.1, Tsepo, please? 0.1. Just one before that. Yeah. Right. You're aware of the memorandum which was sent to Mr. Pillay and Ravele in August 2002 regarding the recruitment of personnel for the so-called unit?
Yes, I'm aware.
Right. And then I think Ms. Mviana went through this. Go to whilst posts were not advertised. Further down, whilst process. Yeah. Okay, I read this out for her. But okay, I'll paraphrase. So essentially there was an admission that the normal, what they call the conventional procedures for recruitment in SARS were not followed. Right?
That is correct.
Then go to that table of names, Tsepo. Again, I won't go into detail, but some of those people there were clearly people with intelligence backgrounds, whether in the defense force or secret service and all that. Correct?
That is correct.
And then at 5.4.3, it's made clear that Mr. Godan had given the approval for this, for the appointment of these people, subject to a discussion with Ivan and so on. But he gave the approval, correct?
It is correct.
Right. Okay, I'm just skimming through if you work with me. Then this is the part I want to go to 5.4.9. So these were some of the people then who had been hired. Maybe illegal is a bit much, in a method that did not comply with those prescripts, which amounted to maladministration in your findings, correct?
That is correct.
Yeah, and again, I won't go through the detail, Chair, for the sake of time, but I just want to show you the kinds of monies that we're talking about. So the salary of and I'm assuming that these are monthly salaries, but we will establish that. The salaries of these people range from 950,000, 630, 600,000, and then the lowest is 285,000. See?
Sorry, Advocate
The
Mpofu.
names. Oh yeah, sorry. Yeah, don't show the names, please. So,
Taken pictures already, you're late.
yeah. Okay, I see it has been captured. Yeah.
Yes, Advocate Bao.
Chair, it's a draft, it wasn't. Chair, can I ask where it says that it's monthly salaries?
No, you can just ask yourself. If you, maybe this weekly salaries, then I think it's obvious that it's these are not. We'll,
Advocate Mpofu,
okay.
I'm asking a question because it's not on the
all
document.
right.
So
May,
you're either testifying or
no.
you have it on the document.
Fair enough. Fair enough. Thank you, Chair. Mr. Mataboge.
Yes, I'm here.
Yes, those salaries that are listed on the right-hand side, are they daily salaries, weekly salaries, annual salaries, monthly salaries, fortnightly salaries?
We understood them to be per annum, which is annual salaries.
Yes, but no, the salaries that are listed, I'm saying, are they? I know I'm actually coming to the per annum thing, which is the times 12. But if somebody was earning, okay, I don't want to go to the names again. Let's go to the last one. Someone got like 285,000, and another one gets 310. Well, did you understand those to be? Well, if it's 285, it means that they're earning like 10,000 or something. Were those? Did you understand those to be monthly or weekly or annual salaries?
We understood them to be annual salaries.
All right, that's fine. We'll bring evidence about that. Okay, that's fine. But anyway, the point I really wanted to make is this: if you add up those salaries, it comes to, okay. No, go to the next one. The next table at 5.4.10. You have a similar table, 5.4.10, Tsapo, without the names. Right. This one starts, yeah, it's 400,000, let's say, per annum, for the purposes of this exercise. It's not very important. 530, 384,000, 410,000, the next person, 235,000, the next one, 600,000, the other one, 530,000, the next one, 235,000, the next one, 470,000, 235, last one, 500,000. We would agree that that's a lot of money in total, correct?
That is correct.
Yeah, in fact, with my limited skills, it's anything between 4 to 5 million rand, even if you exclude the first group of people. Correct?
I wouldn't know that. I'm not that quick with
Okay.
my math and arithmetic.
You are not a maths whiz kid like me. Okay. All right, but you can take my word that it's about between 4 and 5 million. That's just the second batch here. The first batch I didn't calculate, and my skills don't extend to it. Yeah, I think it's probably another 4 million. Okay, anyway, whatever the amount is, this was a lot of money that was the subject of what you found to be irregular recruitment practices, correct?
That is correct.
All right. And then what's important here, Chairperson, is then your findings which you'll find it's 5.4.10.1, or rather the basis of your finding. And my question, I can tell you now at the end, is going to be whether there was any, under these circumstances, any basis to find otherwise. Yeah. But let's go through what you then, having tabulated those large amounts of money, you then say, SARS failed to provide me, and me here is you and the public protector and Ms. Mvian and everyone. SARS failed to provide me with copies of the advertisement for the post, shortlisting and interview documentation for the above mentioned employees. SARS did, however, provide me with a spreadsheet of all advertised posts beginning from January 2006 to 2007. Now, when you say SARS failed to provide you with necessary documentation to justify the spend on this lot of money, is it because you asked for such? Because it would be unfair.
Yes.
Yes, that's what I'm saying. It would be unfair to say they failed to give you the documents if you hadn't asked for them. Okay, that's fine. Then the employment agreements for special agent stated in paragraph 2 that the employee shall serve the employer as special agent as such place from time to time directed by the employer and so on. Okay, that doesn't matter. Okay, let's jump the next one and the next one because it has people's names. Then it says further evidence submitted indicates that Mr. van Lochenberg applied for employment at SARS on 13 January 1999 for the position of assistant director. He was appointed as head of the special operations on 15th, 2007. And here's the important one. SARS failed to provide CVs and recruitment documents pertaining to the appointment of all employees of the intelligence unit. Again, had you requisitioned or asked for such information?
Yes.
Now, then comes my question. Oh no, sorry, let's go to 5.4.25. Oh, 5.4.26. SARS failed to provide me with a policy that applied to the relevant period regulating the transfer of staff within the branches. SARS furthermore failed to provide me with a policy regulating headhunting of staff for positions at SARS. The failure to advertise positions externally is a violation of section 8.3.2 of the SARS recruitment and selection policy. The denial of Mr. Godan in his participation in the recruitment process of one or more of the unit's employees is unlikely. The Skakane report and the Jindra Valley dossier confirm that Mr. Godan played a role in the recruitment of Mr. van Lochenberg. Two questions. The first one is, what is the standard question I've asked you? Those documents that you say SARS failed to provide you, or the policies, and the one that was breached, is are those documents you had asked for?
Yes, because when we write what we call an inquiry letter or document request letter, we list all of the things that we want to assess the complaint against, as well as the allegation against, policies, HR personnel records, and so forth.
Yeah. And so, okay, now then the question I said I was going to ask you, given those facts that we've summarized now, would it have been possible to find anything other than the fact that the recruitment policies were breached, given these facts that we've just gone through?
No, there would not have been any other option but to make that finding.
And also given the amounts of money involved, the large sums of money that we have spoken about, correct?
That is correct.
All right, thank you.
On that point.
Yes, well, your timing is perfect, Chairperson. If that is time for the break, then
It is.
I'm done with the rogue unit anyway. So when we come back after Mr. Mataboge, we'll deal with the PLA report. Thank you, Chair.
Thank you. We'll take a 10-minute break. We'll be back at 11 minutes, 10 minutes past 11. Thank you. colleagues, we will resume with the interaction by Advocate Mpofu with Mr. Mataboge. Over to you, Advocate Mpofu.
Thank you, Chair. Sorry, I just need to. All right, thank you, Chair. Mr. Mataboge?
I'm here.
Okay, good. Thank you. All right. Now, as I said earlier, the only remaining report now of your 4 that we have not dealt with is the Pillay retirement report. And it's not, for reasons that will be clear later, we don't have to spend a lot of time on this particular report. In fact, as I said earlier, I'll use the judgment and possibly refer to only those portions of the report that are referred to in the judgment. But I think it will be easier if we navigate the judgment and then highlight certain portions, and it will become clear what it is that we're going to argue around this particular report at the end. And in any event, Ms. Bauer has referred to this report in the evidence of, I think, both Mr. Van Lochenberg, and if I'm wrong about that, then certainly in the evidence of Mr. Pillay. Can we go to that judgment, Seppo? It's in your judgment bundle, whatever it is, at page 480. Item, I think it's bundle C number 3, judgment 18. Yeah. Bundle C number 3, item number 3. It's the judgment 36099 as opposed to the rogue unit one is 48521. Yeah. Avin Chamnatas Gordon, George Ngakane Virgil, and Visvanathan Pillay. Yeah. Right. Okay, go to the next page for 81. Paragraph 1. Okay, I'll just read this out just to contextualize the report. It says, on 24 May 2019, the public protector released a report on an investigation into allegations of maladministration and impropriety in the approval of Mr. Ivan Pillay's early retirement with full pension benefits and subsequent retention by the South African Revenue Services. The report is the culmination of an investigation conducted by the public protector on the strength of a complaint made anonymously on 18 November 2018 against the applicants and relates to matters which occurred in 2010. Can you just confirm that summary as what this business was all about?
Yes, I do confirm it.
Right. Now, I just like the title, the way the title is of that report is, because I think it covers something that explains the three aspects of what this investigation was about. And I just want you to confirm if the issue was, firstly, the maladministration and impropriety in the approval of Mr. Pilay's early retirement, right?
That is correct.
And the second leg of that was that was not just a retirement, but it was a retirement with full pension benefits.
That is correct as well.
And thirdly, and importantly, that he was subsequently, well, I think that's a bit of an exaggeration, immediately retained by SARS after the quote unquote retirement. I've called it a 1 minute retirement. Right?
Correct.
Yeah, you don't have to call it a 1 minute retirement, but the retirement, quote unquote, happened at 12 midnight. And then at 1 minute past 12 on New Year's Day, he was re-employed. Correct?
That is correct.
Thank you. All right. Now, the reason I'm emphasizing that, Chairperson, is because this whole business, at least the way it was argued in court, is, we called it, well, it's just by coincidence I argued this case, but we called it the package deal, which really, that was shorthand for all these three things, so that we don't have to mention them every time, yeah. But do you agree that at least everyone was agreed that for this whole scheme to work, whether it's legal or not legal, I'm not there for now, but for the whole scheme to work, it had to have all those three elements: the retirement, the retention, and the payment of the full benefits by SARS in particular, and the the payment of the applicable penalties by SARS, and then the retention of Mr. Pillay. If one of them was missing, the whole scheme would collapse, correct?
Yes, that would even be supported by the documents that were provided to us when the initiative of the whole thing started within SARS.
Yes, and the reason why I'm saying it's common cause is because, yeah, you're right. That was, I think it was said by a Mr. Symington, who worked within SARS, that that scheme could only work, or rather, in fact, he even said, if one of those elements is not there, then Mr. Pillay must just withdraw the whole thing. It won't work. That's in the judgment as well. I'm just paraphrasing. Okay, that's fine. Then just for the sake of maybe stating the obvious, the allegations, some of which were quite, shall we call them, stinging, made against the public protector in these allegations were made by Mr. Godan. You're aware of that? In the court papers, I mean.
Yes, I'm aware of that.
Yes. And then at paragraph 5 then of the judgment, Chairperson, the judges then say, and this is important for other reasons, both Mrs. Pillay and Mahashule, sorry, I'm reading in the middle, yeah, have in their respective applications to intervene associated themselves with the submissions of fact and law set out by Minister Godan in the latter's founding affidavit and the relief sought in the review application. In other words, the remarks made by Minister Godan, including the insults and whatnot, and we'll get to those, the others had adopted or hijacked. Correct?
That's how I understand it as well.
The word used is associated.
Okay. Thank you, Chairperson. Now, all right, that's fine. Then let's move on to that. The importance of that will become clear later. And then at paragraph 8, Chair, the amount of the penalty, again, which was common cause, is then stated. it says at the bottom of paragraph 8, a penalty that was levied on Mr. Pilay's pension benefit by the GEPF in the sum of 1.1.41, 1.14 million, 41,178.11 was paid by SARS. So let's say roughly 1.1 million was paid by SARS in penalties in respect of this. And this is where your PFMA investigation was really, as to whether that payment of 1.1 million was regular or irregular, correct?
That is correct.
All right. And then there was, this is also important, Chair, something we will emphasize when we are arguing, particularly in the context of this case. It says the essence of the complaint, I'm at paragraph 9, was that Minister Gordhan and Mr. Mahashula acted dishonestly in their dealing in this matter and placed Mr. Pillay at an advantage. So listen to me carefully. So there were two allegations, one of dishonesty and the second one, let's call it of unjustified enrichment of Mr. Pillay. Remember that, Mr. Mataboge?
Yes, I do.
Yes, because this is important for this vendetta theory. And your findings or the findings of the public protector did not go as far as say finding dishonesty on the part of Mr. Gordhan, but you certainly found the undue enrichment and the PFMA breaches, correct?
That is correct.
Yes. Right. Then, Chair, if we go to paragraph 11, this is where I was saying I'll use the judgment to refer to the report because the judgment quotes the report. So we kill two birds with one stone. Actually, the heading says the report here. Okay, I'm going to read the quoted parts for the record of which really captures the essence of this report. We don't have to go to it here. This is the findings and remedial orders, Chair, quoted in the judgment from the report. So, regarding whether Minister Gordhan irregularly approved the early retirement of Mr. Ivan Pillay with full pension benefits and his subsequent retention in the same position, 1. Okay, AA, there goes again. I don't like that numbering of AA, but it is what it is. AA, yeah, is the allegation that Minister Gordhan irregularly approved the early retirement of Mr. Ivan or Ivan, I don't know how to pronounce his name, with full retired benefits and his subsequent retention at SARS is substantiated. Then BB says, since neither Mr. Pillay's request for early retirement nor Mr. Mahashula's recommendation to Minister Gordhan contemplated retirement, there was no retirement in fact and in law. If there were no retirement in fact in law, it can be concluded that Mr. Pillay was not entitled to early retirement with full pension benefits under any statutory provision. And then CC, even if retirement had been contemplated and there was in fact a retirement, sorry, Chair, I'm interrupting myself. This is, all right, no, well, let me deal with it when I finish, sorry, Chair. Minister Gordhan was not authorized by section 16(2)(a) of the PSA to approve Mr. Pillay's early retirement request with full pension benefits, as this section does not confer any power on minister to approve early retirement with full benefits. Then DD, Mr. Pillay was not entitled to early retirement with full pension benefit under section 16(2)(a). Okay, I'm jumping that. Because the section makes no provision for such full retirement benefits. Section 2A of the PSA only confers a right to an employee to retire from public service upon reaching the age of 65. In terms of that section, no ministerial approval need be sought. And then EE, even if the request for Mr. Pillay for early retirement had been sought in terms of section 16.6, Minister Godan would also not have been authorized to, by that section to approve full pension benefits, because the benefits which the employee is entitled to on early retirement are regulated by section 16.6b and occur by operation of law. No ministerial approval is required. Then the next one is Minister Godan's conduct therefore amounts to improper conduct as envisaged in section 64A2 of the Public Protectors Act. And then when Mr. Mahashula made the recommendation to Minister Godan for the approval of Mr. Pillay's early retirement without downscaling his retirement through Mr. Mahashula, Mr. Mahashula took action contemplated in section 17.4 of the GPF and thereby triggered additional liability to the EPF. And then this is an important one. Payment of the additional liability by SARS amounted to irregular expenditure as envisaged in section 38 of the PFMA and maladministration as contemplated in section 6.4 of the PP Act. Minister Godan also acted ultra vires in approving the retention of Mr. Pillay as Minister Godan was not authorized to do so. Now, all that, and I must, speaking for myself, commend you for a very well written, or logical at least, because you say, if this happened, if this did not happen, even if that happened, this and that and so on. But that's just aside there. Bottom line, Mr. Mataboge, is you may not remember word for word what the report says, but I'm going to try and summarize it and subject to your confirmation. That the applicable laws were breached in that the retirement, because of the age of the person and the applicable sections, they did not tally, they didn't make sense, correct?
That is correct.
Okay, so that's the broad, let's call it the pension, or rather the retirement issue, quote unquote. And you also found that this 1 minute retirement was not in law, did not qualify as a retirement, whatever it was, but it was not a retirement, correct?
That is correct.
And then lastly, you found that the payment of the 1.1 million by SARS in penalties did not conform with the PFMA.
That is correct. That is correct, Desmond.
Yeah, and then that retention, I mean, was well, that the minister acted ultra vires, which means exceeded his authority. But this is the most important thing that maybe is missed here. One of the essential issues about this is that it's what in the language of the anti-corruption brigade, which I used to be part of, or the chairman of National Anti-Corruption Forum. There's a form of corruption called, commonly known as the javelin. You familiar with that?
I've often heard about it.
Yes. Yeah, no, it's not complicated. It's the situation where I'm working here for this committee, and then the chairperson says, we need to procure computers for this committee, and I'm the procurement person, and I realize that this is such a nice deal. Then I resign after doing the procurement work. Then I go to the other side and work for a computer company and receive the javelin that side. It's that kind of thing. Now, and it's usually associated with public officials for obvious reasons, but I think even in the private sector, it's probably prevalent because the people can still procure goods even there. But anyway, the point I'm making is that one of the things that gets missed in the Pillay report is that when Commissioner Godan made the initial request for this, he was a commissioner of SARS, but subsequently when it was now being approved, he was the minister who was approving it. Am I correct?
Yes, I remember so, but I can check.
Yes. Okay, fine. Now that also comes from the judgment. And the suggestion, or rather the finding from the public protector, was that the real reason behind the favorable or favorite treatment of Mr. Pillay was because of their quote-unquote friendship or political kinship or long-standing comradeship, that kind of thing. You remember that?
Yes, that came out during the interview meetings we had.
Yeah. Yes. Okay.
With SARS and Minister Godan.
Yes. And the most important thing here is that Mr. Pillay, I don't know whether I was saying this to you or to Ms. Mkhwebane. So Mr. Pillay features both in the rogue unit report as somebody who has been favored by achieving the great heights of being SARS commissioner, armed only with a matric. And now he emerges in this particular report as a person who's favored for this package deal with at the expense of SARS, so to speak. Now, as a person who was involved in both reports, you probably are the best person who can make that connection, that he emerged in both reports as having been favored by Mr. Godan, correct?
I will not use your words, but you are central, if I may use my words.
Yes, no, fine. You don't have to use my words, but let's maybe try and make it simpler and more palatable. In the rogue unit report, the allegation had been that Mr. Pillay had achieved the status of commissioner for SARS with armed only with a matric undeservedly, correct?
Yes, correct.
And in the Pillay report, the allegation, which was substantiated, was that he had received this package deal and the man was paid at the expense of SARS or the taxpayer also undeservedly, correct?
That is correct, yes.
Yes, okay, that's fine, that's sufficient. And one of the issues was that it was not clear, some of the memoranda, the earlier ones, he said it's for the education of his children, then it changed, it was for health reasons, then it changed, it was for personal reasons, unstated. But there was a gray area as to exactly what was behind the scheme, correct?
That is correct. Even one HR official, I think, was also asked for an opinion, and he also, had his misgivings about this whole thing and advice. Yes.
Yes. Thank you. In fact, yeah, let's go to paragraph 18, Tsepo. That's a reference to one of the internal officials at SARS, correct?
That is correct.
A Mr. Kutsia.
Yes, that's correct.
Yes. Paragraph 18, whom you interacted with as Public Protector's Office, correct?
That is correct as well.
Right. Okay, so let's cross. Thank you. Instead of going through Mr. Kutsia's emails and all that, I'll just paraphrase it as it is put here in the judgment. So Mr. Pillay's memorandum was referred to Mr. Nick Kutsia for advice by Mr. Mahashula. Mr. Kutsia advised that Mr. Mahashula to recommend the request of Mr. Pillay to the minister and that the minister must approve if there are sufficient reasons to do so. So it was a qualified statement, correct?
Yes.
And then the part that I think you are referring to is then said, however, he cautioned Mr. Magashule about the cynical nature of the transaction, as it would be technically construed as SARS contributing from its budget money for the schooling of Mr. Pilay's children, and that the reappointment in the same position of Mr. Pillay will raise eyebrows. Is that what you are referring to?
That is true. That is the reference I was making.
Yes. In other words, even this official was saying that this just looks like a finder, and that this was it at face value would look like SARS is just sponsoring the education of Mr. Pilay's children, particularly if he was going to be reappointed in the same position, correct?
That is correct.
Yeah. And let me say this, because this is something that the public protector is going to testify about. Some of the reasoning or the allegations from Mr. Kotan and the others was that there was nothing unusual about this kind of scheme. You remember that?
Yes, I do remember.
But in fact, and demonstrably so, I don't have to deal with it with you in detail, but I'm putting it as strongly as this. There's nobody in the entire world, or in, well, I don't know about the world, but in South Africa, either before Mr. Pillay or after Mr. Pillay, who was ever a beneficiary of a scheme like this in its totality. So in other words, there might have been someone who had early retirement, there might have been someone whose penalty was paid by the employer, but there might be someone who was retained and so on. But to have all three in one package was unprecedented, and were able to demonstrate this. The examples that were given, all of them were distinguishable or different. So they gave names of people, and it turned out that that person was over 65 or was not retained or whatever, but no one that you could find who had benefited in the same way, correct?
That is correct.
Right. That's the one important feature. The other important feature, and fortunately the court agreed with us on this, is that Mr. Kotan said he had relied on quote unquote legal advice of 6 experts. And therefore he was comfortable that even if this was wrong, but at least these so-called 6 legal experts had confirmed it. But it turned out that that was false. Either those people were not legal experts, or they had, some of them had never even spoken to him, or they had not said what he said they said. And those people are listed at paragraph 21.1. Mr. Symington, Mr. Andrew Donaldson, Ms. Minnie Hendricks, Kenny Govender, Michael Olivier. You remember that he relied on the so-called quote unquote advice of those experts.
Yes, that's what he alluded to in the meeting we had with him. Yes.
Yeah. Okay. We don't have to worry about that. The court found that all the things that I've just summarized. Then this is important again for this committee at a broader level, Chairperson. This is, I was looking for this passage, I think, when I was talking to Ms. Mviana about this business of 2 years, the 2-year limit. I think I informed the committee that this was the first case in which that matter was actually debated by a court, but at that time I couldn't find the passage, but here it is. Paragraph 29. And this is apropos whether the public protector can be blamed for something which even the courts had not even dealt with. It says, at the time of the hearing of the application, the issue pertaining to the special circumstances envisaged in Section 6(9) of the Public Protector Act appears not to have been dealt with by any of our courts, except for GEMS, which did not specifically deal with the issue at hand. Counsel could not provide us with any authority that might have been of assistance to us determining the issue. We could also not find any such authority. It appeared at the time that this court might be the first to be seized with the issue. Then subsequent to the hearing, but prior to this judgment, a full court division in Godan, that would be the rogue unit matter, has subsequently dealt with the issue incidentally between the principal role players in this application. So effectively, this issue, which is now heaped on the public protector, was dealt with almost simultaneously for the first time by two courts in the reports that you were involved in. Is that so, Mr.
That is correct, Robert. That is correct.
Yeah. Okay, then let's move on. Paragraph 34. Then it says, in oral argument, Mr. Mpofu, on behalf of the public protector, contended that the jurisdictional point must not succeed because the applicants in their respective arguments on this issue failed to conceptualize the issue. This, he says, is so because, according to him, the applicants take the approach as if this is a typical prescription provision, which means it is a provision that prohibits the public protector from entering complaints that are more than 2 years, whereas it is a time bar provision. According to Mr. Sonso, this is a permissive provision and should be given a purposive interpretation. This section, as it were, falls under the heading, quote, reporting matters to and additional powers to the public protector, which indicates that the section is meant for the benefit of the public protector and not for the benefit of the alleged transgressors. Anyway, that was the debate, which was not accepted by the court. But the point I really want to emphasize is that this was the first time this matter was being dealt with judicially, correct?
That is correct.
And the next issue, which was central to this, was this question of special circumstances, as to whether the special circumstances must be subjectively in the mind of the public protector or objectively determined. But we don't have to get into that. It says, Mr. Hatton was the opponent. Okay, let's start at paragraph 47. Mr. Mpofu's argument that because the public protector has wide powers and subjective nature of her discretion, deference is given to her to determine the special circumstances is not entirely correct. He is correct that the public protector should determine the special circumstances. Section 6(9) of the Public Protector Act provides as much. The difference is only that the determination of the special circumstances must be an objective rather than a subjective fact. And then it says, as Mr. Hatton, that was the other side, says, then he says, obviously, he said the opposite. Anyway, long and short is that the court found that there was an inference that if you don't articulate those special circumstances in writing, then they don't exist. And I don't, because I was involved in this, I'm not allowed to comment on that. But that is what was eventually found. You remember that?
Yes, I remember.
Yes, okay.
But if I may comment on this one as well, is that at the time this judgment were passed, we would have, in the normal course of investigations, canvassed the Section 6(9) applicability with the respondents. But at the time, it was not seen as a key element in the investigation, because even the respondents at the time who were still engaging with them before the 7(9), they would have had to raise it as an objection. But at the time, it was not yet in the legal space, as it were.
Yes, But also, again, you probably are the best person who can assist us in this because you were involved in both investigations. In both investigations, the point that, at least this is my personal view, as I say, so don't take it with a pinch of salt because I was involved in the matter. But one of the issues which the court, at least from the camp of the public protector, had overlooked was what you and the public protector were saying about this, which is that let's assume the 2-year rule applies. Let's even assume that it applies as a prescription thing. But when you are dealing with conduct that is ongoing, even as you are investigating, then you can't say it's 2 years old because it's ongoing.
We call it continued prejudice.
Absolutely. And I was trying not to put it in legalese, yeah. But you're quite right. But the point is, now I'm coming to the facts. As far as you are concerned, both in the Pillay report, the issue was that Mr. Pillay was continuing to be paid this pension. In fact, presumably he's still being paid the pension even today. Correct?
I believe so.
Yes. And in relation to the rogue unit, your contention was that there were still ongoing spying activities and therefore it could not be thrown to the past. So that's just a matter of fact, even assuming we accept the legal interpretation of the court.
Yes.
Thank you. All right. Okay, then we come to the important part, which is more relevant to this. And unfortunately, well, again, you can take this from me as an aside comment. In fairness to the court, just like in the Busasa matter, some of the pronouncements of the courts, which probably show even-handedness on the part of the courts, just simply don't get reported in the media for obvious reasons, I suppose. But in this particular case, actually the court had very strong words to say to Mr. Kodan and even punished him with an attorney and client costs order for insulting the public protector. Do you remember that?
Yes, I do.
Yes. And this goes to his theory, which was expressed in the Section 7.9 response in the rogue unit report, and even in this one, that the public protector was actually playing a political game, targeting him, and part of state capture and corruption and all sorts of things, instead of addressing why Mr. Pillay was allegedly being favored. Correct?
That is correct.
Yeah. Now, Chair, I'm just going to, if you forgive me, I'm just going to read out some of these are the extracts from Mr. Kodan's affidavit to that effect. And they are quoted in the judgment at paragraph 66, Tsepo. Go to paragraph 38 of the quoted paragraphs. Yeah, this is what Mr. Kodan says. More importantly, okay, let me maybe just to contextualize it for the members. One of the proposals made by Mr. Kodan was that this was just after the election in 2019 and between, like we are now, at the time of the announcement of a cabinet. And Mr. Kodan's argument was that the public protector only released the thing on the 24th of May, because the inauguration, which I attended, was on, I think, on the 26th or so. And we know traditionally a few days thereafter the cabinet is announced. So the theory was that the public protector was releasing this report so that Mr. Mkhwebane should not be appointed to cabinet. That's the context here. All right. Then at paragraph 38, he then says in his affidavit, more importantly, on 23 May 2019, the letter confirmed that the report would be issued the very next day on 24 May 2019. The timing is suspicious and indicates that the report was politically motivated. I say this because there was no reason for the unseemly haste with which the report was issued on Friday, 24 May 2019, a mere 48 hours following the delivery of my submission to the public protector in response to the notice of the draft findings on Wednesday, 22 May 2019. I can only conclude that the rush to complete and issue the report within 2 days of the receipt of my submissions and those of other implicated persons was informed by improper and irrelevant considerations or an ulterior purpose or motive. By this, I mean to refer to the presidential inauguration of the third respondent held on Saturday, 25 May 2019, and the political context in which my political opponents have sought to use the complaint lodged with the public protector and now her report to attack my integrity, and so on. And says there is no other plausible explanation, he says at 35.2. And that that it shows that she did not have an open mind. Then here's the sting at paragraph 40. I believe that the report was issued when it was issued, with the findings and remedial action it contained, so as to enable a renewal of the ongoing political campaign against me by proponents of state capture and defenders of corruption. In other words, the public protector was in cahoots with criminals, because that's what they would be, who are known as proponents of state capture and defenders of corruption. And that is why she was releasing the report at that time. And then at 40.4, he says, this track record, like this committee, referring to other judgments, as set out in bringing this new application, I join a long line of litigants who have to run to the courts to ensure that this public protector, and Advocate Mkhwebane in particular, acts in accordance with the law and the Constitution. This track record of adverse findings against the Office of the Public Protector and Advocate Mkhwebane specifically demonstrates, in my opinion, that she is unfit for the office and that she holds and appears unable lawfully, constitutionally, to exercise its power. And so it goes and goes about the suspicious mind and what have you. And then he says that it also showed her stunning incompetence, he says. And that those were the headlines, I think, for the rest of the week. But incompetence, of course, is what we are here to investigate. And Mr. Mkhwebane already passed judgment on it. But this committee says he is irrelevant. But anyway, this is what he says. Go to 9.7 of the next set of quotations. Oh, this is the public protector's response, Chair. At 9.5, the serious allegation that the report was issued, quote, so as to enable 9.5, yeah. Yeah, that the report was issued so as to enable a renewal of ongoing political campaign against Mr. Mkhwebane by opponents of, quote, state capture and defenders of corruption. Again, not even a single shred of evidence is produced to support. The clear meaning of this is that the public protector is a participant or accomplice in a conspiracy together and in concert with criminal elements, to wit, proponents of state capture and defenders of corruption. If this were indeed true, then South Africa's hard-fought democracy would be irretrievably damaged, and such a public protector would be guilty of the crime of treason, punishable by death in many countries. A bigger insult against the public protector is very hard to imagine, said the public protector. And then she says, the related averment that I am, quote, seemingly in service to some other motive or agenda, and this is another important one, the inclusion of a long and irrelevant passages from unrelated court decisions, allegedly to demonstrate inter alia my, quote, stunning incompetence in the performance of my duties, and the unwarranted and substantiated and misplaced averments that I'm unfit for my office, which ought to be the subject of disciplinary action. Then she says that in any event is something that would have been in the hands of Parliament. Then the next paragraph 69. The court then goes on to deal with the fact that everyone can be criticized, but there must be what is called ethical limits to such criticism. In other words, the duty to then produce. But perhaps the biggest insult to the public protector was this thing that it would be impossible for her to deal with Mr. Kotan's response, Section 79 response, which was not even that long, in the space of 2 days of 48 hours, when lawyers deal with bigger documents in, at any stage for anyone who's legally trained. And this is what the court had to say about that. Paragraph 76. It is indeed so that the public protector received Minister Kotan's response to the Section 79 notice on a Wednesday, and on Friday morning, within 48 hours, she released the report allegedly condemning Mr. Kotan's misconduct. Mr. Kotan wants to suggest that the report cites rims from his submissions, but does not deal with them, and contends that further that the public protector could not have dealt with the representations within that short space of 48 hours. And then says the court, the premise that the public protector cannot deal with a representation received in the space of 48 hours is unfounded and meritless. Firstly, the evidence shows that the report already existed in near complete form at the time the public protector received the representations. Secondly, the public protector states categorically in her answering affidavit that when she received Minister Kotan's representation, she analyzed it and found nothing therein to persuade her to change the report. Unless, of course, there can be evidence to indicate that the public protector was lying, that she never actually analyzed the response of the applicants to the Section 79 notice. This remains an unsubstantiated allegation and runs into the Plascon-Evans rule because of the dispute. And the court, in its credit, says the following, which is true. And because it characterized this for the demeaning and racist connotations, or sexist even, that it carries. The court then says at paragraph 78, it is also condescending of the applicants, that's now Mr. Kotan, Mr. Pillay, and Mr. Mahashud, it's condescending of the applicants to want to argue that the public protector would be unable to deal with their representations within a time period of 48 hours. The record shows that indeed the notices were dealt with, that they might not have been dealt with to the satisfaction of the applicants does not detract from the fact that the representations were dealt with in the report. Thus, the applicant's argument that the public protector did not consider their responses to Section 79 notice is unfounded. Since the further allegations that she was politically motivated and that ulterior motives informed the report are also unsubstantiated. There's no evidence to establish that allegation, none at all. And then it summarizes the argument of the other side. And here's the important explanation of the so-called inauguration allegation. Paragraph 81. You remember those paragraphs, Mr. Mataboge? In the judgment. We lost him.
Mr. Mataboge?
I'm here. I had muted myself. I'm here. I remember the.
Oh, sorry. Okay, no. So
apologies.
You were answering to a muted. Well, be careful what you wish for. The chairperson will mute you if you don't answer. So okay, so no, I was saying, yeah, you remember those paragraphs that I've just run through from the judgment now?
Yes, I do. I do remember them.
Yes. Paragraph 81 then says the challenge, however, for the applicants, that's Mr. Godan and the others, is that the public protector explains in detail in her answer affidavit why she had to release the report on the date she did. According to evidence, the Office of the Public Protector traditionally releases reports in batches or clusters of 5 or 6 unrelated reports. The present report is said to have been scheduled for release together with other 5 reports on Friday, 24 May 2019, without any knowledge by the public protector of the date of the inauguration. The other 5 reports are named in her composite answering affidavit. Any haste, if there was any, is explained by the public protector as, quote, purely motivated by the need to meet our self-imposed deadlines. There is nothing on record to gainsay these averments by the public protector. Anyway, paragraph 89 then says, this, however, does not mean that the paragraph should not be struck out. When the amendments made by the applicants in paragraphs 38, 39, 40, that's the one about the corruption and all that. And so
my apologies, Advocate Mpofu and Chairperson. Mr. Mataboge just called me now. He's coming back from load shedding, so it's going to be cut off and you should be joining soon.
All right, thanks. Maybe you can answer the question.
Thank you. Thank you, Mr. Ngoma. We'll take 2 minutes, just a pause and wait for Mr. Both?
Thank you, Chair. I thought the quorum is 19, but I'm happy with that cross section. Yeah, but that's fine.
Every round.
As a what do they call it? Representative. Probably the most important passage in this judgment relevant to this committee, which will be raised in argument, is paragraph 86, which explains clearly the role that the judiciary actually should play no role in the impeachment of a public protector. And also basically says that Mr. Kodan should know better than to call the public protector incompetent and not fit for office and so on, when as an MP he could have just put a motion to deal with that. And then it says, on the averment that the public protector is unfit for her office, she contends that the averments are unwarranted, unsubstantiated, and misplaced. More so as they cannot be lightly or appropriately made or pronounced by either a member of the executive, such as the Minister Kodan, or even this court as part of this judiciary, but can only be articulated by the legislature in terms of the doctrine of separation of powers. The making of such averment is said to be nothing short of a gratuitous insult by the wrong person in the wrong forum. The submission is that these impugned paragraphs should be struck out on the basis that they are irrelevant as they relate to an issue which, to the knowledge of the applicants, falls outside the jurisdiction of the courts. And then it says later there, for as argued by the public protector, even if these allocations were correct, there is nothing that the court can do because the separation of powers. The proper approach is to refer such complaints and allocations to Parliament. We're in agreement and accept Mr. Leroux's argument, that was one of the opponents, that paragraph 38, 39, and 40 cannot be read in a way that could be held to be insulting, contemptuous, and defamatory because they all form Minister Kodan's belief, sincere belief. Minister Kodan sets out paragraphs 30, 40, his subjective belief, and so on. And then at 89, it says, this, however, does not mean that the paragraph should not be struck out. When the averments made by the applicants in those paragraphs are construed, whether individual or cumulatively, they can be construed as nothing else but gratuitous averments based on suspicion. The averments are therefore vexatious and made intending to annoy the public protector. A similar finding based on allegations couched in similar terms by Minister Kodan has been made in Kodan at paragraph 267, 268. So the exact finding was made in the rogue unit case at those paragraphs. So I won't cross-refer directly, Chair, because it's obvious. Paragraph 267 or 268. They should similarly be struck out in this application. And then paragraph 91, this is something that again is not well understood by non-lawyers in particular, so we need to just deal with it, not as opposed to a fault of their own. It says, this was about now this issue of Minister Kodan relying on judgments, previous judgments, to show how bad the public protector is. It says, it is alleged that those paragraphs specific reference, I'm at 90, sorry, of repeated admonishments that the public protector received from the courts to comply with the Constitution and Public Protector Act, and where she was mulcted with personal costs as a result of a failure to do so. Relying on the National Director of Prosecutions, that's just a case. The public protector in her heads of argument submits that the allegations relating to other court cases ought to be struck out as irrelevant as they constitute the opinions of other courts, the decision of which of some are still pending. And then the court, in agreement with that amendment at paragraph 95, says, the Court in Institute for Accountability in Southern Africa, that's another case where Advocate Hoffman wanted
Chair, I can't hear Advocate Mpofu on my side.
Chair, it's gone totally silent.
Yes.
Okay,
IT.
let's try again.
Okay, can you hear me now?
Yes, we can, Advocate Mpofu.
All right, thank you.
On my side.
Okay, fine. No, then I won't go back. I don't know where I lost you, but it's easy. I'll just paraphrase it. I'm now dealing with the situation where there was reliance on other court cases. Did you lose me before I got to that?
No, after that, we dealt with the one for.
Good. No, then you didn't lose me for long, yeah, because I just started on that topic. Yeah. All right. I was saying that in agreement with the submission that the court could not itself declare the public protector not fit for office, nor rely on the opinions of other courts. This is what the court said. It quoted a case called Institute for Accountability, which stated the rule and qualified it, but for the purposes of this case. And I'll quote the quotation, so to speak, Chair, which was at paragraph 31. This is what the court then says. Ultimately, the rationale for the Hollington rule is that the findings of previous court constitute the opinions of that court. That is what the court found. This was Judge Coppin, I think. And that for that reason are irrelevant and inadmissible in subsequent civil proceedings. Even though such findings constitute expressions of opinion, they cannot be equated with the opinions of ordinary individuals and cannot be treated as such. Those findings were made by judges and confirmed in certain instances by the justices of the higher courts. Judges have a duty to form and express opinions concerning issues raised before them, and that's the important thing, including those that are relevant to in the context of this matter. And they arrived at those opinions aided by procedures which was designed to ensure that they base those opinions on the correct information. Those opinions are also binding on all persons and those organs of state to which they apply. Now, that's an expression of Section 165 of the Constitution. You don't have to worry about that. But the gist of that is that the court, it's expressed in Section 165. Court decisions, A, are binding to other courts, but obviously they're also binding to the parties, the people who are involved in that particular litigation. You would know that as a lawyer from your law of evidence, Mr. Mataboge, correct?
Correct,
yeah. And then it says, for all these reasons, the impugned paragraphs must be struck out as irrelevant. In other words, on the basis of those submissions on opinion evidence, on gratuitous insult, and lack of, and the wrong forum and all that, they were struck out. Now, the important issue about this, Chair, is that, and I'm not going to go into the merits, then the judges go into the merits and they find that some of the findings in in your report, they find against them, although there's a curious one, which I'm not sure. So somehow all these things we spoke about, the javelin and all that, the judges find that that's fine. And Mr. Kutsia's concerns and Advocate Brass's opinion, which was that this was not the right thing to do. But then there's one which I'll have to debate with Advocate Bauer, which I also noticed only recently, where they said at paragraph 213, under these circumstances, we have to conclude that the public protector's finding that Minister Godan acted ultra vires in approving the retention of Mr. Pillay was rational. What I really wanted to drive at is that Minister Godan, in this judgment, even though it was portrayed as in the media for obvious reasons, as a victory for him, but it was very scathing, to say the least, on the gratuitous insults and condescending remarks that he had made against the public protector. And to that extent, he was ordered to pay him, not only him, both him and Mr. Pillay and Mr. Mahashule, because as we said, they had adopted his affidavit, including the insults. So you'll see the order at the end. It says the first, second, and third, I'm at 590 or paragraph 8, right at the end. 590. No, so you can even, okay, just go to paragraph 249 of the judgment. Oh, I'm so sorry. Go to 238. This is also an important paragraph to which I will refer the committee, because again, this, and again, maybe because we are lawyers, we take these things for granted. About the difference between a court, let's say, finding that there was no Audi alteram partem or this and that prescript had not been followed by a litigant such as the public protector, which happens every day, I mean, by the hundreds. So every day somebody, some functionary in a municipality or a province or whatever, or an SOE is found not to have followed a particular prescript. That happens every day. If people were to be impeached for that, there will be no one left in the country. And to distinguish that from situations where there are impeachable offenses. And that the fact that a court has found against you really is, as someone said, is probably a good thing and an educational thing, and guides you as to how to move forward and so on. But it's neither here nor there. And so the court made that distinction clearly here, because Mr. Godan and the others wanted the public protector to pay punitive and personal costs on the basis of the findings against her, which were made by the court. And the court said at 238, Chair, in light of what is stated above passages, we are of the opinion that the circumstances of this application do not warrant the ordering of a personal cost order against Advocate Mkhwebane. The test set out is that of bad faith and gross negligence. It does not appear in the papers before us that Advocate Mkhwebane conducted these proceedings in bad faith and was grossly negligent. The fact of this matter do not support such an order, and we are accordingly not inclined to grant such an order. So that didn't detract from the fact that they had found against her on the findings or yourself. And just for good measure, she was mulcted with punitive costs in relation to the Rule 69 issue. That is the jurisdiction, the 2-year thing, which again, speaking for myself, bearing in mind that this very court said that this was the first time this matter was being tested in the courts, but that's what happened. Yeah, I just don't want to mislead the committee on that aspect. But at 250, which is the part that you won't see in the newspapers.
Whilst having that pause, let me just recognize, I see a hand of Honorable Milam.
Thank you, Chairperson. Chairperson, I apologize for interrupting proceedings, but on a point of order, it appears that Mr. Mpofu is now testifying. I didn't hear a question in that long soliloquy that he has just made of all these various sections of this case that he has quoted, but he didn't put a question to Mr. Mataboge, and I have a bit of a problem with that, Chair.
Okay, well, maybe still coming to that, but Advocate Mpofu.
Thank you, Chairperson. I take strong exception to the use of the word soliloquy. That's take strong exception, but I'll take it from whence it comes. Mr. Mataboge, do you recall those portions in the judgment, insofar as you have confirmed that you've read it?
Yes, I do. I do, Advocate Mpofu.
Thank you. All right. Okay, we were at paragraph 250 before we were rudely interrupted. 250 of the judgment. It says, we conclude, and I'm just putting the thing in perspective of the cost issues. We conclude as a result of that cost should follow the event. As per our decision, the public protector should pay the costs of the applicants in the review application on an attorney-client scale, as well as costs to Minister Godan and Mr. Pillay in the counter application on a party and party scale. Okay, so this puts it in perspective. As I said, that on the merits, there was an attorney-client scale, and then on the, counter application, that's the one about, I haven't dealt with you. It was about contempt of the public protector. But, and then it says on the, this is the part that part obviously got reported. And then here's the part. On the other hand, Minister Godan, Mr. Pillay should pay the public protector's costs pertaining to the strikeout application on the attorney and client scale. The applicants must also pay the public protector's costs pertaining to the departure grounds on review on an attorney and client scale. I've also not discussed that with you. That one was about the Minister Godan. Firstly, the first attorney and client scale order against him was for the insults. And then the second attorney and client scale was for insisting on bringing that case under PAJA. When we had pointed out, we actually had written letters to them to say PAJA does not apply to the public protector. So, but that's just a legal thing. It doesn't show much malice. Yes, Chair. Okay, then I don't have to refer you to the court orders because they summarize what I've already just said there. So that is the Pillay judgment. And thank you, Mr. Mataboge. You said obviously this was your baby or your one of your reports, so you are familiar with those findings and the passages, just so that there's no doubt and that I'm not accused of a soliloquy. Did you or any other Shakespearean conspiracy? Did you were you familiar with those findings and you confirm them?
Yes, Reverend Bofu, I confirm them. Like I said yesterday, that whenever there are judgments, we sit as investigators with our legal services in our conference room and discuss as well as learning curves and teachings for our work going forward. Yes.
Right. Thank you. Now, I've asked you this before, and although at least on this score, it was mitigated, I think, by the comments of the judges in two important ways, by rejecting the gratuitous insults, but also by stating where they felt so that even though they might have found against yourselves, there was nothing to warrant personal costs against the public protector. But to the extent that you were collectively, that collective that adopted each other's insults on the one side, and then there's the collective which is the target of those insults. How did you feel about now being accused of such big things as being a conspirator to state capture and attempts to influence the appointment of cabinet and all those things? How did that make you feel as a professional?
Just like I said, yesterday, it doesn't augur well for one as an investigator, even a chief investigator at that, that even your colleagues let alone the colleagues outside the public protector, they look, with you at you in a different way. They then affect how you do your work, your self-esteem, and some would even, talk about your cases. I remember on one or two occasions I had to stand my ground in one of the conference room engagement as staff to try and put matters into perspective. But it does affect you personally, and for sure, anything that affects you personally and professionally will augur bad for your future, as a professional for that matter.
Yes. Yes, okay. No, I think that's important because you're right. Not only does it affect you now, but yes, as you put it in the future, if you are one day, maybe you might be looking for another job or another opportunity, and then you are identified as one of those state capture apparatchiks or practitioners. No, thank you. So now, if you can just help the committee, I'm just taking advantage because you are here and you are an investigator and an experienced one. There's another issue. It concerns in the main allegations which were made in the reports that you were not involved in CX and Friede. And I will raise it with Advocate Madonsela when she comes. But I'm asking you from a different perspective because I think Mr. Kodan made a similar accusation. It's about this whole business about the public protector expanded the mandate or the scope, or in another case, she narrowed it and so on. Are you familiar with the Mail and Guardian case?
Yes, I am a advocate.
Yes.
I am very much.
Yeah,
Yes.
not word for word. I mean, just the thrust of that case, yeah. Because this
Yes,
is another.
we cite it all the time in our, as part of the reports we issue, as the one that informs our investigations. You know, where
Yes.
we may not have cited it, it would have been just a miss, but it's always there.
Yes, no, that is true. Sorry. In fact, you've just reminded me. So maybe I should just go to an example of where you do it. And I'm doing this just to show again, you know, I don't know whether it's let me not ascribe it to any deliberate action, but I'll argue this at the end. There's a conflation of court proceedings on the one hand with investigative proceedings such as yours, and then another conflation of adversarial and inquisitorial proceedings. In fact, we had hoped to bring an expert to these proceedings, it's just that we didn't get around to it, to explain some of these concepts and the law of evidence, how it works, what is relevance, and what is this and the other. But outside of that, let me just use this because, as you correctly say, it appears in every report. Is it your understanding that the public protector is confined to the four corners of a complaint, or that if the evidence leads, unlike a court, as you know, you and I would know, a court is confined to the pleadings. If I plead something and I say you stole my car, the court will look into that issue, not as to whether you also stole my motorcycle and so on, unless if I've pleaded it. You get what I'm saying?
Yes, I do. I do.
Yes. Now,
and I'm familiar with that. Yes.
Yes, thanks. That's a court of law. Now, in an investigative process such as this one, does that also hold? So if I complain about my stolen car and in your investigation you find that someone also stole my motorcycle and my goat or whatever, are you confined, or must you turn a blind eye to those things just simply because they were not in the original complaint?
I think the mail and guardian judgment here is key in that it criticized the public protector, you know, when they were dealing with that judgment, to say the public protector must go out there and find out the truth and mustn't just take what is being brought to his or her attention. And as such, that's what we follow as investigators. And if I may take it further, is that when, for instance, you investigate one matter and you find that there are systemic matters that also relate to almost a similar conduct, we then widen the scope and do what we call systemic investigations. And it becomes a very wide. You cannot just say because you found one ID having been fraudulently issued, then you just ignore the rest. If I may just use one of the simpler cases that doesn't relate to conduct failure. Yeah.
So as a matter of principle, does it even make sense? Is it logical to accuse the public protector of widening the scope of an investigation beyond the complaint, or even narrowing it for that matter?
No, it doesn't. I may even take it further, you know, by referring to the PP Act. I think it's section 7 in brackets 1B, Roman figure 1. That talks about the format and the procedure to be followed into conducting an investigation. That says it shall be determined by the public protector with regard to the circumstances of each case. That is the section from the Act. So this talks to the mail and guardian judgment somewhat.
Yes, thank you. And if we, as a country now, when I say we, if we want to confine the public protector to the four corners of a particular complaint, then we would have to change the legislation to indicate that, correct?
That is correct. As far as I see.
All right, then let me just summarize. As you say, this is standard. I think almost all your reports contain this, but maybe the members might not have read it, or even if they read it, not understood it in the context that I'm presenting it now. So just this is a random example. You'll find it in every report, but let's go to 6228. Tsepo. Sorry, I think there's another mismatch in our numbering. Go to 9.1.11. Thank you. Right, okay, let's just use that one as an example. I'll read it out, Mr. Mataboge, and at the right places, I'll ask you if you are familiar with it. Okay. It says, in the seminal case of the public protector versus Maryland Guardian, the court held that the public protector is not a passive adjudicator between the citizen and the state, relying only upon evidence which is placed before her by the parties. The Supreme Court of Appeal held further that the public protector should not be bound or limited to the issues raised for consideration and determination by the parties, but should investigate further and discover the truth, and also inspire confidence that the truth has been discovered. The court further made it clear that the mandate of the public protector is an investigatory one, requiring pro-action in appropriate circumstances. Although the public protector may act upon complaints that are made, he or she may also take the initiative to commence an inquiry, and on no more than, quote, information, not even evidence, information that has come to his or her knowledge of maladministration, if malfeasance or impropriety in public life. If I may just pause there. This was at the heart of the case which we argued, I think, in 2017, which, if I'm permitted, I will raise with Advocate Matansel, the turning point case that gave us the Zondo Commission, called the state capture case, as to what is the level, because the other side representing the president then was saying, no, the public protector must have evidence. And we argued that even information is enough to successfully in that case. Anyway, it says the court emphasized that the public protector has a proactive function. He or she is expected not to sit back and wait for proof where there are allegations of malfeasance, but is enjoined to actively discover the truth. And then just in closing, it says, although the complaint by Mr. Maimane had been lodged in terms of the EMEA, Mr. Maimane had in the same complaint also requested that the suspicion of money laundering should be probed due to the manner in which the transaction relating to the payment of the CR17 campaign went through several intermediaries before reaching its intended beneficiary. Okay, we covered that yesterday. Yes, and now the gist of it is 9.115, where you say, or the public protector, or sorry, I don't know if this is a report you're involved in. Oh yeah, it is Busasa. Where you say, I've therefore deliberately decided to cite the above case law and further lay this short background in order to address or dispel any misguided notion or contention that I have unduly extended the scope of this investigation without just cause, And that is, well, at least we will argue that there's the same misguided notion that afflicted Ms. Mazzoni when she articulated her various complaints about the alleged expansion of the mandate from, let's say, Ms. Matanzela's version of the issues and the other issue. So is okay, in your experience, does it happen often, frequently, or rarely that the final report covers either much wider scope or a narrower scope than was originally envisaged by the complainant?
It does happen often in respect of other cases as well, like both.
All right. Sorry, Chair. Okay. Now, all right, no, and there's just one small thing on rogue unit, but I don't want to go back to it and then come back to this. I'll deal with it separately. Rule 53, Ms. Mviana testified that she, at her level, and the legal people, internal and external, would get involved, but it didn't go much higher than you. Can you confirm that I suppose even you would get involved peripherally, but that anyone higher than you would not normally get involved in Rule 53, compilation of Rule 53 applications? Of Rule 53 records?
Yes, her explanation is correct. I was involved. You know, myself, my involvement is more quality assurance, so it's minimal as well, because there's quite a lot to do here as a chief investigator.
Yeah. Okay. So well, this happens even in government departments or anywhere. I don't think anyone ever expects the minister or even the DG to be compiling Rule 53 records. So in your situation, your Rule 53 record would be compiled by the people on the ground, really, who do the spade work, correct?
Correct, correct.
Okay. Okay. 8:16. Sorry, Chair, just rounding up. If we go to 58:16, no, sorry. No, sorry, it's that SC story, we've dealt with that. Thank you. All right. Then if we then go to 59:31, Okay, thank you. Okay, just one or two issues. Mr. Mataboge, if you don't mind us just going back to one or two issues that I just omitted to raise in the when we were dealing with the rogue unit. The first one has to do with this whole thing of the IGI report. The public protector, when she testifies, will confirm, as I said, that she openly and and consistently stated that she had sight of the report, and all she was trying to do was to get it declassified, so that and that's why she laid charges against the minister, and I think the minister laid charges against her, and all sorts of things. But so there's no doubt that she both saw the report and used it the IGI report, and used it in the PP's report. Now, there was a suggestion here. Well, firstly, do you confirm that the public protector then was, as she will put it, responsible for any contents in the report that emanated from the IGI report? Was that your understanding?
Yes.
Right. And what was then put to you, the public protector will literally own up to that, and then explained also, and she will explain the points in what you called last week the toing and froing of the documents, the points at which then she would populate those documents with the information at her disposal. But what was suggested here was that by some reasoning which has to do with your computer skills or lack thereof, which cannot be worse than mine, that some of those changes were at least went through your hands, let me put it that way, because they were highlighted in yellow, which apparently is your trademark way of correcting.
Who said that? I want to know who said that.
I'm not revealing the whistleblowers.
Exactly.
Someone revealed that. Well, another whistleblower told me that you don't even have a WhatsApp. That's how. So I think I'm ahead of you. But on a serious note, to the extent that those changes were clearly done by you because of your highlighting tendencies, did that then mean that they came from you, or were you dealing with them as they came from the public protector?
No, once it's highlighted yellow, it would mean that it is coming from me, because so that there's a distinction between what might have been inputted by the PP or even by the investigator herself. So that is why it's one of those practices, as I used the word practice earlier on. The
practices, yes, yeah. And so then, to the extent that you could have, let's say, inputted on the formatting of a particular section, or the framing or whatever, maybe using previous, using whatever you were using. The point I'm asking is, if you then did some work on a particular section, did that mean that you yourself had read the report, or you would have been formatting what someone else, you could have been formatting what someone else had inputted, whether it was Bianca or the chairperson or I'm sorry, or the public protector or anyone else?
Yes, even not necessarily having been inputted, maybe having discussed with PP, of the document, either telephonically or, And then I would input it like that, having understood it to come from her in that context. So that when then it goes back to her, she must see my input on it.
Okay.
Based on how I understood her, that it
Yes.
has come out also.
No.
Yeah.
That's fine. No, the point I'm making is that it was suggested that simply because you had commented on it or highlighted it or whatever, or worked on it, then it meant it was an indication that you had read the report yourself. Can you assist us on that?
No, not necessarily. That's what I'm saying. It would have been maybe through a discussion with Ms. Mkhwebane or even PP. And my understanding of that discussion, then I would incorporate it that way and highlight it so that it must show that it's new text that is coming into the report now.
Yes, okay, thanks. No, that's fine. So, all right. And you see, you must move in with the times because now your footprint is easy to your primitive methods. Yeah, you must come to me for IT lessons. Yeah. All right. No, that's fine. I just wanted to clarify that. And then the last one, Chair, is I'll take you to 5931. That is, and it's important that I'm dealing with this now, with us having traversed what I've called the gratuitous insults of Mr. Kodan in relation to the Pillay matter, which, as I indicated, were similar, I think, and similarly referred at paragraphs 267 and 268 of the rogue unit matter. So I'm now dealing with the insults in general because they appeared in both matters. Do you understand that?
Yes, I do have it both. I do.
Okay, you follow. All right, thanks. So
yes.
These are then some of the issues that Minister Kodan raised in his response to the Section 79, which we know now that ultimately they were rejected by the court and he was punished for them. But and hopefully that makes you feel better. But I just want to see how, what I call the source, because what is often missed, I think, in this committee is that the source of these charges, and I think I've been at pains to point this out, were the people who actually made them originally, such as Mr. Ramaphosa or Mr. Kodan or Ms. Mazoni or whoever packaged the insults, if there's such a thing. Yeah. But at paragraph 3, 5933, Chair, I think I'll only need 5 or 10 minutes. So, yeah. At paragraph 5933, I'll just go through them again, and I'll ask you in between so that I'm not accused of testifying, but I'm just trying to do this for time. Paragraph 3, Mr. Kodan says the following. He basically says, look, I'm giving you this response, I don't want to do it, and so on. But then he says, I do so, however, despite my serious misgivings about the current public protector's conduct in this matter, and indeed her fitness to do this investigation and make the findings proposed in the notice. She has shown herself to be implacably biased and indeed seems to be driven by a single-minded determination to tarnish me and others with her reckless investigations and findings into complaints laid by my political adversaries. I shall not allow her to do so and will protect my constitutional rights to fair and reasonable administrative action and maintain integrity. Can you see the resemblance between this particular insult, which was, by the way, rejected by the court, and charges 11.1 and 11.3, which really are that you and the charge public protector and the others were single-mindedly determined to isolate certain people and handpick them for political vendettas, what we discussed earlier. I just want you to see that this must be one of the sources of that particular allegation. Can you see the resemblance between the two?
Yes, I do, Adwin. I do.
Yes. And then a similar question arises from later in that document. Yes, I think it's paragraph 51, Sapo, at 5949. In the same vein, and I'll ask you again of the resemblance between this and what we discussed in the judgment and then the charge 11.3 and 11.4. So the establishment of the unit was perfectly lawful. The public protector's proposed findings to the contrary are wholly unjustified, erroneous, and intended to serve a political purpose or other ulterior motive. Can you see that resemblance there as well?
Yes, I can see it.
And the last one is at page 5952, paragraph 66. The public protector proposed findings against me substantiating complaints laid by my political opponents are unfounded and are explicable only by bias and ulterior motive. I won't ask you how you feel about that, but do you understand it to paint you with that same brush then of political campaign, for lack of a better word?
Yes, I do, especially when we are the ones who are the foot soldiers and who even sit in these meetings when people are subpoenaed by the PP.
Yes. Well, thank you, Chair. I just wanted to say that you, oh, sorry. Yes, I wanted to just say that, you know, yesterday we closed on a note where you said that you were worried that, because I was hoping that you are out of danger, but, and to the extent that there might be other people who might share your worries, I hadn't thought of that, that maybe as it normally happens, the victimization might start with the public protector or the insults or the harassment or whatever is happening. But that it could, you said, we sometimes get worried that they will come for us as well. And I just wanted to say that, you know, that reminded me of what I want to close on, because sometimes people, we sometimes get drunk with power and forget how quickly the wheel turns, and or the words of Mkhwebane CJ in that judgment, that we must do unto others as we would like others to do to us in the same situation. And I don't know if you've heard of a gentleman called Martin Niemöller, who addresses situations like that. And I'll read it out to you. Maybe it will make you feel better, or if you haven't heard it, if you have, you must look for it. He says, first they came for the socialists and I did not speak out because I was not a socialist. Then they came for the trade unionist, and I did not speak out because I was not a trade unionist. Then they came for the Jews, and I did not speak out because I was not a Jew. Then they came for me, and there was no one left to speak for me. I think the importance of those words is something you must Google if you are able to use Google. Thank you very much. Thank you very much.
Somebody defamed me about my
I know.
IT.
Your IT skills or lack thereof.
Hey.
Thank you very much, Mr. Mataboge. You've been very helpful, and I know that I've taken you to some of these areas, but I think it's useful for this committee to have had someone like you and Ms. Mviana, who are involved, the actual practitioners, as opposed to the leadership of that institution. Thank you very much. Thank you, Chair. Chair, I'm done, but if I pick up anything during lunch, because I can see that there are some whispers, then I'll ask for a minute or two, but it's unlikely, Chair. I think we've covered everything.
Thank you, Advocate Mpofu. We're going to pause there for 45-minute lunch, and we'll come back at 5 to 2. It will be the 10 of the members when we do that. Is there something you want to throw in?
Yes, Chair. No, I had forgotten our arrangement about addressing those other issues. I'll do it. Maybe can I do it when I come back, or I can do it at any stage, as long as you won't punish me for missing the deadline.
That's when
you come back. Thank you, Chair. Okay.
Thank you. Let's have lunch. Thank you very much.
Recording stopped.
25 Just before I proceed, because we got an unusual gift just before lunch. You have to be surprised. It's a very unusual gift that we got from one advocate in Mpofu, who saved and gave back time. Doesn't often happen, but that's a gift. So thank you very much, Advocate Mpofu, for returning the time that you always claim, and that goes back to you. So it's a nice rewards.
Thank you, Chair. Thank you. I even fought for Advocate Bauer to get more time last week. But who gives me the credit?
Thank you.
Thank you.
Thank you. And with that, I would like colleagues that we maybe would also take his example. He would have been given certain time and didn't really have to utilize all of that time. I'm going to be inviting members to interact. I'm hoping that we will do that in a very focused way and conclude well on time. Even though we're scheduled to end at 5, I don't mind if we conclude even earlier than that. So I'm in your hands. I'm not saying don't ask your questions. Can I now invite members to raise their hands? Before that, Advocate Bauer?
You know, I did indicate to you this morning, as well as to Advocate Mpofu, that there were issues that arose from the documentation that we were provided, and that from Advocate Mpofu's cross-examination that I would like to deal with after the members, of course.
Yes, because this is now not your time. You can indicate that when it is the opportunity for you. Thank you. Honorable Mananiso. Honorable Gondwe. Honorable Mylan. Maneli. Those are the hands I have. Oh. Those are the hands I have, colleagues, of members wishing to interact. Now, as I am about to close the hands, there's more hands coming. Honorable Suela. Are there any further hands, colleagues, up in the air? So that we know that these are the hands that we're going to focus on. Thank you. And those are the hands I have. Honorable Lagude. Thank you. Let's proceed in that way. Honorable Mananiso.
Thank you, Chairperson. Chairperson, I've switched on my video just for you to register me. Can I switch it off?
You're welcome. Thank you.
Okay. Thank you, Chair. And let me pass my greetings to Advocate Mataboge and evidence leaders and their teams. My first question to Ntate Mataboge is that, can Ntate Mataboge define the leadership style of Advocate Mkhwebane for me as an icebreaker? Chairperson, can you hear me?
Yes, we can hear you. Mr. Mataboge is just about to respond.
All right.
Afternoon, Honorable Manaliso. I'm not advocating Mr. Mataboge.
Okay, Ntate, okay.
You asked me a very...
He's got the question. He's got the question. Thank you, Mr. Honorable Mananis.
You've asked me a very difficult and perhaps even a technical question. If you talk about leadership, well, then it means one will have to define leadership and management style as concept. But to try and answer you, Mkhwebane, I worked with her during her stint as the senior investigator. And she then left and came back and joined the institution and as our leader now. So this bit of background for me would then show that she would then have had to adapt or to adjust herself to being part of us in the past, leader. Or I think the right word is our leader. And for me, the one that I knew at the time, she was a senior investigator, did not change much.
That the road blackouts contribute to the economy.
Well, I don't know whether that's what is happening going more in the office. People who battle phone and others.
It's not me, Advocate Chairperson. It's not on my side. I think it's on the honorable member's side. I'm all by myself.
Yes, it's my side, Chair. Sorry.
Please mute then, and then only unmute when you have to speak. Apology for that, Mr. Mataboge. Please go ahead.
If I may then summarize my long, I don't want to belabor the definition. I want to just say they normally call leaders, some of whom lead from the front, some lead from the back. But with that a bit of this distinction, public protector, that is African Mkhwebane, has been for me leading with us, a par or a pace with us, because she was not leading from the front. As far as I observed her, working with her for the period that I was under her supervision as the public protector, and myself being the chief investigator for all these cases that came before her. She's also a hands-on leader, if I may use the word hands-on, because she also gets to be involved. She wants to know what is happening every day within the workspace. I think I should stop here because I don't want to be technical about what is leadership, what is management.
Okay, thank you, Tate Mataboge. Then my second question to you, say, as the person who's been at the PPSA, I think you believe in this notion that everyone is equal before the law. And I want to believe that maybe me and you, we are on the same page of understanding that it's regardless of the authority that you are serving in or you are deployed or employed in, that everybody across is equal before the law and people must be treated fair. And I just want to check with you, do you think this particular process, it is fair or unfair, more especially when there's a prima facie evidence, yes or no?
Which process, Honorable Manani?
So this process of section 194 that we are in, of fault finding mission.
If I were to talk about the proceedings with what is being brought forward, I would say it's fair, because so both sides of the parties at dispute, if I may use the word, the parties at dispute are being heard and given enough hearing, if I may use the word, yes. I hope I've answered your.
You did answer me, sir. Thank you. You did answer me. We had evidence from Ms. Mvuyana that the investigation of the SARS unit was kept closely between her, yourself, and the PP. Why was this the case?
I'd rather leave this. I'll try to answer a bit, but I'd rather leave this to the PP herself. Like I cited a section in the Public Protector Act earlier on, that says the process and the procedure to be followed in investigation is determined by the PP. It's a sole right. But I think when I talked to, I think it's Advocate Bauer, I said that sometimes the lesser hands are involved in crucial and critical investigation, the lesser risks of crucial and sensitive information coming into the wrong hands. That is how I personally viewed it. But I think PP would be the best placed person to respond to that question, because we didn't choose ourselves. She was working with us, and she pointed us out to work with her in the investigation.
Oh, okay, Dr. Mataboge. And then my fourth question to you is, are you aware that the IGI report was never declassified and it would have been unlawful for unauthorized individual to process the report?
Yes, I was aware.
All right. And then my follow-up then would be, would you agree that both yourself and the PP were not authorized to process the report?
I'm not sure, because I and PP have got the top security clearance. I'm not sure. I'm speaking under correction here. I never thought so.
All right. All right. Dr. Mataboge, those are my questions to you. Thank you, and for answering those questions. Thank you, Chairperson.
Thank you, Honorable Mananiso. Honorable Mailam.
Thank you, Chairperson. Good afternoon, Mr. Mataboge.
Afternoon, Honorable Mailam.
Mr. Mataboge, let me start where Honorable Mananiso left off and ask you, if a person has top secret clearance, does that mean they are authorized to view any top secret document?
That is my understanding of having obtained the top secret clearance from where it was given to me. That was my understanding. Yes.
Sorry, someone else came in and commented. It's your understanding that because you have top secret clearance, you can view any top secret document. Is that correct?
That's what I'm saying, Honorable.
Okay. I'm going to suggest that that's actually an incorrect interpretation, and that you're only entitled to view documents that you are authorized to view. But let me leave it at that. Let me turn to another matter. Yesterday, Mr. Mpofu took you through various court judgments, and he took you through the Concord judgment in the SARS matter. And he in particular highlighted the opinion of Chief Justice Mkhwebane, and he.
Sorry, just a pause, Mr. Mataboge and Honorable Mailam. I just have a hand here.
Yes, no, sorry, Chair. I'm sorry to interrupt. I think Mr. Mailam is making a mistake, but just for the record, that was in the Busasa matter, not the SARS matter.
I apologize.
Thank you for the correction. Over, back to you.
I apologize. Sorry, that was the Busasa matter. He's quite correct. But that was a minority judgment. Now, I want to ask you, as a qualified legal person, what is the value of a minority judgment of the Constitutional Court against the value of a majority judgment of the Constitutional Court?
You can't compare the two, because the other one is a majority decision, the other one is a minority. But that doesn't stop one from, as I was saying yesterday, as much small as it was. Myself, as the investigator of the matter, I felt a bit vindicated, but not in the bigger scheme of things, wherein the matter had not been viewed by other majority decision in court.
So let me put it another way. The minority judgment has no impact on the outcome. Is that a correct
Correct.
interpretation?
Yes, correct.
Okay, and the binding outcome is the majority judgment.
Correct. That is correct.
And there is no higher court than the Constitutional Court. Is that correct?
That is correct.
Which means that the decision of the Constitutional Court to set aside a report or to dismiss an application, that is the law. That is the finding. That is the end of the matter, and it can go no further. Is that a correct understanding?
That is yes. That is what happened, I believe.
So let me ask you this. If that's the case, why are we sitting here debating the minority opinion?
I think you're asking the question to the wrong person.
Well, you expressed an opinion on it yesterday, and I'm asking you, in your opinion, why are we debating the minority judgment?
I don't understand when we say we're debating it, because it was Advocate Mpofu's presentation of his version or his argument.
Okay, and you agreed with him.
As far as minority judgment is concerned, the way he depicted it, I agreed with what was in the minority judgment.
Okay, let me turn to another matter, and that is the quality assurance on the various reports that you issued. What was the process that was followed from the investigator to the final sign-off of the report?
Which report, Honorable Mayor?
Well, let's go with the SARS, the alleged rogue unit report. What was the quality assurance process that was followed?
The quality assurance is the same throughout, depending who is the investigator, because it has to go through myself as the chief investigator, having been drafted by the senior investigator. Then it has to go through the executive manager, and then it goes to the COO, then it goes to the public protector, and sometimes even our legal services.
And yet, we've heard evidence that in this particular report's case, it went from Ms. Mvuyana to yourself to the public protector. It did not go through the executive manager, and it did not go through the COO. Is that correct?
Yeah, but that is not for me to determine and to answer. Like I said, we serve at the behest of the public protector.
Would you agree that then impacts on the quality of the report itself?
I'm not sure. I'm not sure to what extent.
Well, I asked Ms. Mvuyana whether she thought that report was a shoddy report, and she asked me what did I mean by shoddy, and I pointed out various shortcomings, and I said to her, let me rephrase it. Did she think it was a quality report? And she said no. So in light of that evidence, do you agree that there were shortcomings in the quality assurance process of that report?
I don't agree with that.
Okay, let me highlight a few issues there, and then you can tell me whether you still hold that position. So there were witnesses that were never interviewed. Do you agree with that?
I'm going to refer you to the section 7.1b that I referred to earlier on about the determination of the format and the procedure to be followed in each investigation. When we investigate, we don't have to, let's say in the earlier depiction of names that were there when Advocate was leading his evidence, there are almost how many people's names there. If then we determine that we need to interview all of them, we should form a basis for interviewing all of them. So as a result of us trying to determine who not to investigate, who not to call for interview, who not to involve, it is on the basis of what we regard as maybe material evidence that we will want, and what is the focus of the investigation, for instance.
Fair enough. But if you issue a 7.9 notice, that means that you believe that witness has material information for you, surely.
Issue a 7.9 notice to the witness, you mean?
Yes, if the Public Protector's Office issues a Section 7(9) notice, that means that you as the investigators believe that there is material information that can benefit your report, surely.
Yes, if we issue a 7(9), the 7(9)A says you issued a 7(9) to implicated and affected parties. And then that is when the materiality part comes into play.
So you agree that if you issue a 7(9) notice, that witness has material information that you would like to interrogate or investigate?
Yes.
Okay.
That's why we're offering him a chance, him or her a chance to respond to the 7(9) notice.
Now let me take that one step further. We heard from Ms. Mvuyana that the process followed in actually serving the 7(9) notice on Mr. van Lochrenberg was very, very weak. Would you agree with that?
I don't agree that there was 7(9) to be served on Mr. van Lochrenberg. As far as I recall, there was a problem with the subpoena, not 7(9). If I recall my facts correctly.
Just
so it's not a 7(9) notice.
Thank you. Just a pause there. I've got a hand here from Advocate Mpofu.
Okay, thank you, Chairperson. Now I wanted to assist Honorable Milam again, but I think the witness has just done so. Thank you.
Okay.
Thank you.
So if it's a
Honorable Milam, please continue.
Thank you, Chair. So if it's a subpoena, let's use the correct terminology. If it's a subpoena, there's obviously material information at that point, surely.
Yes, at that point, correctly so, at that point.
Okay, so you were trying to serve a subpoena on Mr. van Lochrenberg. Now, the process that was followed in serving that subpoena, would you agree that that process was flawed?
I wouldn't agree, because this argument, Honorable Melam, keeps on cropping, and I said to the team and even to Ms. Mvuyana to say, we are not like the other investigating institutions who are the public protector, and we try by all means to serve the subpoena our way, but we are not like the police, wherein we then go and do a search and seizure and look for people. And we tried our best in the circumstances to serve the subpoena.
Well, let's explore that a little bit. What your best involved? You spoke to a whistleblower at SARS who gave you incorrect information about Mr. van Lochrenberg's address, correct?
No, that is not my word. Who says that?
That's the evidence that that's the evidence that we heard from. Go ahead.
I wanted to say we requested information from SARS on the former employees of SARS from their personnel records. So I don't understand when now you talk of a whistleblower, Honorable Mela.
Ms. Mvuyana said that the information of Mr. van Lochrenberg's address came from a high-profile whistleblower in the Human Resources Department of SARS. It was not a formal request for information. It came from a high-profile whistleblower, was what she said.
When we wanted to save all these former SARS officials, we requested for information from SARS. That is why even on the day the sort of not well served subpoena, or the day it was served, the messenger went to all those other addresses which we would have sourced from SARS, from their personnel files, including Mr. Magachula, all of them that were served.
Okay, we're talking about Mr. van Lochrenberg. So
yes, I'm saying he was part of the subpoenas that were being served on the day. I think plus minus 6 of them to the former SARS officials.
Okay. Can you point us to the official correspondence to SARS requesting those addresses?
I'll have to go to my records. Not now. I'll have to look for the.
Well, why is it not in the Rule 53 record?
I'll have to ask Ms. Mvuyana, because she's the one who dealt with the Rule 53 record. I'll have to ask her.
Okay, because she said that it was the whistleblower. But okay, let's put that aside. What other steps did you take when it came out that the address was incorrect? What other steps did you take to ensure that the subpoena was correctly served?
No, once the messenger returned, Ms. Mviana then searched. She says she went on Google. She tried to search for the address. And the other thing that happened, the people also provided us as a team. I think with the court date that I wonder if it was not already out of time or it was in time on the day the Mr. Rohanberg was going to appear in court for us to try and serve it.
And why didn't you serve?
But that did not take place.
Okay. Why didn't you serve it on his attorneys?
I was not aware of his attorneys at the time.
Even though you'd had correspondence from his attorneys only days before?
I was not aware of the correspondence that you're referring to, Ms. Melam. At the time the court appearance version was being brought to us.
Okay, so what I'm hearing, and correct me if I'm wrong, is that your efforts to locate Mr. van Lochrenberg extended only to an address that was provided by somebody in SARS and a Google search.
Yes.
Do you think that is adequate?
Please wrap up that last question.
Yeah. Do you think that is adequate in terms of your investigative responsibilities? And if not, is that not indicative of a shoddy investigation?
No, I wouldn't say that. That's why I even explained to Honorable Madam that we are not like the Hawks and the SIU and other people. We are not the police. We are the health protector. You know? So I wouldn't share that sentiment.
Thank you, Chairperson.
Thank you. I'm going to the next speaker, but before that, I see a hand.
Yes, no,
Mpofu?
thank you, Chair. No, I just wanted to assist Honorable Malam again, but just for the record, that the evidence doesn't accord with what he's saying, that there was correspondence from the attorneys days before. The evidence is actually that non-service was in April and the attorney's letter was somewhere in mid-June. Thank you.
Okay, thank you. Honorable Siwela. You are recognized.
Thank you, Chairperson. Dumela Tate Mataboge.
Dumela Honorable Siwela.
Minjani.
Ke tsogile o kae mme?
Ke teng. Na dipotšišo tša ka ke maelana le report ye IGI. Ke batla ho tseba ka gore PP will I submit. I will submit a court that report. So ke batla ho tseba gore na report yone ile ya surrender na to the IGI as requested by the letter from the Minister of State Security on the 20th of February 2019. Ona le botsebe ba tšeo.
Because that the response would best be coming from the PPSL or even the legal services, because I recall the legal services people were involved, but now that it's only PP and I that are here, maybe PP can assist when she testifies.
Okay, thank you. Ya bobedi ke batla ho botsisa ka dilo tša authorization. So were you or are you authorized by law to possess a classified report if you have a top security clearance? Because
no, I think this question has just been asked by the honorable member that asked before you, who says that just because I've got a top security clearance doesn't mean that I'm authorized. I think based on that, I'll take his word for it.
They are not authorized. Thank you for that. So, ke batlo tseba gore at any moment, have you ever been instructed by the PP to omit certain information while you were working from the Rule 53?
No, never. When we work on the Rule 53, the public protector is even sometimes not aware of where we're working and what we're doing. It's very, 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 very far removed from a space. Even our executive managers sometimes don't get involved, don't get involved in the Rule 53.
Thank you. Ke dipotšišo tše be ke nna tše tšeo, ke a leboga.
Thank you, Honorable Swell.
Thank you, Honorable Siwela. Honorable Mautwe. Honorable Mautwe. Honorable Ompile Mautwe. Ayo. Oh, just a hand there. Okay. Honorable Bondwe.
Sorry, Chair.
Yes, Honorable Mautwe.
I've got a problem with my signal. Were you calling me, Chair?
Yes.
Oh, okay.
Please go ahead.
Ke a leboga, Chairperson. Dumela Rre Mataboge.
Dumela, Honorable Mautwe.
La tsoga Rra.
Re tlotse mmele kae?
Re tlotse. I've got just a few questions for you. The first one would be, did Ntate Jamnada Skodan confirm or deny that he was part of the establishment of the SARS unit, the so-called rogue unit?
At what stage, Honorable Mautwe? Because we engaged with him during the meeting and he responded as well. I'm trying to find out at what stage are you referring to?
At any stage? Did at any stage he confirm or deny?
I think when you use the word rogue unit, it will become a problem because he talked, when he was saying it was lawful, the establishment, he talked of the NRU, I think, not necessarily the rogue unit, that it was lawful and inactivities were lawful. So he did not deny.
Let's call it the SARS unit. I said the one that is well known as the rogue unit, but let's call it the SARS unit. Did he confirm or deny that he was part of the establishment of that unit?
No, he confirmed.
Okay. Let's move. So we are in this process that emanates from the motion that comes from Honorable Mazzoni of the Democratic Alliance. That's why we're here. It was the beginning of the process. Now, is there any substance to the charges from Honorable Mazzoni that the public protector shielded politicians like Ace Magashule, the former Secretary General of the ANC?
No, that's why even when I was asked this question by Advocate Bauer, I was saying those charges, I think it's 11.1 or 11.4. I did not agree with the charges because, like I was saying, we conduct our work in the PP in the best of our ability as well as bona fide as possible.
Okay, am I correct to say that you are involved in the 302 matter personally?
Yes, I was.
And then to your knowledge, at any stage, did the public protector try to influence you in any way?
No, not at all. Even during all the other investigations as well, because as a team, we sit and discuss with people, we persuade us to her thinking, we try to persuade, we to and fro as an investigation team.
Okay.
Before we arrive at a particular narrative, we don't just take it from her as such.
Okay. My last two questions. If the former Chief Justice Ntate Mokgwe's judgment in the Bosasa matter taken into account, shouldn't the NPA on its own charge the sitting president criminally for lying under oath in his responses to the public protector?
I would
The sitting
rather not
president-
comment on. I'd rather not comment at Honorable Mount on that, especially in light of what I've just been told, that the legality of the minority decision it remains just a minority view, not the majority decision of the court.
Okay, I'll give you that. That's fine. My last question is, so Advocate Mkhwebane was able to ask 31 questions, very good questions, to the sitting president within 1 week of getting the complaint. And then we now know, as a matter of fact, that the acting public protector has not released the Palapala report 9 months later. Is that the new standard? And is that standard, should it be acceptable as a professional standard now that is in the office of the public protector?
I would want to desist from commenting, but in desisting as well, I would also say, as a chief investigator who's been involved in many of these cases, they always use the word with the teams that I supervise, that sometimes the matter snowballs. I use the word to snowball. And once the matter snowballs, it doesn't look like what it looked like before you started working on it. It may even then go beyond the turnaround time that one or you had envisaged yourself or even other people outside.
Shouldn't it be a priority number one, this matter, more so that it involves number one of the country, a respondent in the country? So shouldn't it be priority on the desk of the public protector?
Once again, I would want to desist, but I must say it would be priority, and depending on what is contained and what information is being grappled with by the team that is in, unfortunately I'm not involved. It sometimes doesn't become as easy as it may seem from a distance. With us being the team inside, we'll be grappling with lots and lots of issues on an investigation, perhaps even the one like this one. I'm speaking from the experience when I was involved in the Bosasa one for that matter, yes.
Okay, no, thank you very much, Chair. That will be all from my side. Thank you.
Thank you, Honorable Mautre. Honorable Gondwe.
Thank you very much, Chair. Dumela Mataboge.
Dumela Honorable Gondwe.
Le kae?
It was the Melikai.
Re teng papa. Ke na le dipotso tse pedinyana tse tharo. But I ask you to be patient because ke santse ke tla go botsa ka the IGI report. I know you've already fielded a number of questions around that particular report, the classified report, but I just want to make sure that I've understood you. All right. My first question is, does the fact that a report is already in the public domain result in, and when I talk about a report, I'm talking about a classified report. Does the fact that a classified report is already in the public domain result in that report losing its classification?
I don't think so, because classification is a formal process. So it doesn't mean it necessarily loses it. Yes.
Okay, so if a classified report is easily available in the public domain, it does not lose its classified status, right?
That's my view, yes.
Yes, because I also understand it like that, that the law around this issue is that until a report is declassified, its unauthorized possession is unlawful in terms of the Protection of Information Act and the Intelligence Services Act. So whether or not you have top secret security clearance becomes irrelevant if your possession of the report is unauthorized. Do you also understand it in that way?
Yes, I've just been told by earlier on by an honorable member, I think it was Mananiso, about the fact that once I mustn't think that because I've got top security clearance, it entitles me or authorizes me to have access to the report. That's what I was told.
Okay, so at the time that you, Advocate Mkhwebane, and others in the Office of the Public Protector had access to that classified report. Were you under the impression that your possession of the report was authorized and lawful?
Yes, based on the security clearance aspect that I've just been corrected on now, yes.
Okay, thank you. In the course of your oral evidence to this inquiry, we saw an email from Advocate Mkhwebane to yourself. In that email, Advocate Mkhwebane stated, amongst other things, that Pravin Gordhan must face his day in court and that he's a threat to democracy and he must stop before he causes more harm under the guise of cleaning up. And when Advocate Bauer asked you about the email and its contents, you responded to say Advocate Mkhwebane sent it to you simply for noting. Now, Mataboge, was that email simply for noting because it contained a host of questions in it? And you know, for me, it came across as an instruction as opposed to it being simply for noting. Was that email not drafted in the form of an instruction to yourself to make sure that you conducted the investigation in such a manner that the outcome of the investigation ensured he was stopped because he's a threat to democracy?
Okay.
I'd want to be shown the email again, for me to comment, because I don't recall that email during the engagement with Advocate Bauer.
Okay. Whilst we're doing that, I have a hand. Just need to recognize a switch off. So for now, Advocate Mpofu.
Thank you, Chair. Chair, I checked with that question. It's a deliberately misleading question. This email was canvassed with Ms. Mkhwebane, who said that, at least to confirm the fact that it came, I think she said
she couldn't confirm anything. I don't think.
No, wait.
On a point of order.
Wait, let me
You can't
speak.
feed the witness an
Okay.
answer that was given and was retracted.
No,
Okay, I've not recognized you though.
No.
Please wait for me to recognize you.
Chairperson?
Okay, please
Yeah.
conclude, Advocate Mpofu, and I'll come back to you, Advocate Mpofu.
Yeah, Chairperson, I really don't appreciate to be interrupted like that rudely. It's, yeah. Anyway, no, Chair, I'm saying the evidence before this committee, which was led through Ms. Mkhwebane, was that that particular email, I think she said it looked like it came from a complainant or somebody like that. And it was canvassed with her repeatedly, and even the mistakes, the Judge Nugget and all those things. And she clearly indicated that it didn't resemble the style of the public protector. All I'm saying, I'm not saying which version, whether that version or the other version of Advocate Bauer is correct. She seems to be too keen. She forgets that she's an evidence leader, not a prosecutor. And yeah, no, you forget that you are not a prosecutor. Okay, sorry, I'm addressing you, Chair. She forgets that she's not a prosecutor and her job is not to sponsor a particular narrative as opposed to another, but to get to the truth. So I'm simply saying that if that question is asked, and I'm not saying the question should not be asked, then in fairness, it should not be put as Advocate Mkhwebane sent to you and she did this or another, as if she was the author of the email, when that issue is in dispute. That's all I'm saying, Chair. I'm not saying questions should not be asked. I'm just saying fairness demands that the witness is not misled deliberately for nefarious purposes to pursue the agenda of Ms. Mkhwebane or Ms. Bauer or both.
Advocate Bauer?
Chair, I'm not pursuing any agenda.
I mean,
But
Dr. Gondwe, sorry, not Ms. Mkhwebane, Dr. Gondwe and Advocate Bauer or both.
I did not recognize you now.
I apologize, Chair.
Advocate Bauer?
offense at that suggestion. But the point was, Advocate Mkhwebane, Ms. Mkhwebane wasn't even included in this email. She accepted that was the case. The question was put with reference to the evidence which was given by Mr. Mataboge as the recipient of the email. Ms. Mkhwebane, when questioned by myself, said she was speculating about it. She couldn't even recall if she had actually been a recipient of this email. And so for Advocate Mpofu to elevate it as undisputed evidence before this committee, or evidence in dispute by somebody who wasn't even sure that she had received the email and to whom the email had not even been addressed. She further said that she didn't think this was an email from the PP because there was no names above to whom it was addressed. And when I pointed out to her, well, actually there were several emails from the PP in exactly the same way, she agreed to that. So I think that it's wrong for Advocate Mpofu to offer an answer that wasn't based on the question that was put to the witness. He should be allowed to answer without a different answer being provided by Advocate Mpofu.
Chairperson.
Okay, thank you, Advocate Bauer.
Sure.
I want to move back to the
Yes.
member. Let me get your point.
Yes,
Advocate
thanks,
Bauer.
Chair. No, I have a right of reply. Thank you, Chair. No, I think it's it now borders on something that I cannot describe to suggest that I'm offering an answer. I think that's actually the highest insult that can be suggested to me. I'm not doing anything of the sort. I'm not offering any answer. I'm not. What Advocate Bauer is doing now is a matter of a legal argument, which we will both have a lot of time to deal with when the evidence is being assessed. I'm simply saying it's factually true that you cannot ask a question. You can't say, one witness says the thing is blue, the other one says it's white, and then you say, you ask it as if there is no controversy about that question, and pose it as if, and say, she said, Advocate Mkhwebane, when there is evidence before this committee of whatever value or weight which will be discussed at a later stage. That is not the case. It's just not fair to the witness. It's misleading. And number one. Number two, Chair, and I don't want to waste your time. Advocate Bauer should not be huffing and puffing about a particular version. It's not her job. She's an evidence leader. She's not a prosecutor. Even a prosecutor wouldn't do what she's doing, because even a prosecutor would understand that the question must be asked fairly and answered fairly. I can understand Dr. Gondwe, maybe she's not a lawyer, or at least a practicing one. But Advocate Bauer knows that what I'm saying is correct, which is that the question must be put in its proper context and with all versions of it. And that's all I'm doing. Not in a misleading way calculated to trick the witness.
Thank you, Advocate Mpofu. I'm going to come back to you, Honorable Gondwe, to pursue your question, if you're getting answers to it.
Mataboge, were you able to capture my question?
Yes, I had captured it. I tried to respond to say, let me see the email that the question is based on, because I don't recall the email myself.
Okay. Can we have the email, Tsepo? Over to you, Mr. Mataboge and Honorable Gondwe.
Can we, through Chairperson, can Tsepo go up?
Yeah, she has a challenge with up and down, so you might need to assist there.
She must go to the address, Chairperson.
Okay, thank you.
Yes, Chairperson, I see, but I don't remember the email, because it's so loaded that I don't remember it indeed. It was 8 November 2018, even when one of the files was just being opened. I don't know if it was the SARS or even the one relating to Busasa, but I don't remember the email.
remember the email?
Yes.
Okay, Honorable Gondwe.
So, but do you remember what I asked you about the email? What my
Yes, I
question was?
remember. Yes, I remember the question that
Because
you
I
said
recall-
it would mean it was an instruction.
Yes, because you.
That's the gist of your question.
Yes, allow me to finish, because when Advocate Bauer asked you what she meant by saying that Mr. Gordhan is a threat and he must be stopped, you indicated that you saw it as, simply for noting. So my question to you was, did you not see it as an instruction?
We'll have to
Honorable, make sure
we'll have
that
to go to sorry, Chairperson and Honorable Gondwe. I was suggesting that we'll have to go to the record. This is not where I said it was for noting. I don't remember me saying that. If we need to go to the record, maybe we have to go there and then listen to my answer. Okay,
no, it's fine. And then in the course of your evidence, we were shown another email in which Advocate Mkhwebane suggested that the Bosasa draft report be shared with SC. Do you recall that email?
Yes, I recall the email.
Okay. And then in that very same email, you agreed with Advocate Mkhwebane that the Bosasa draft report be shared with SC. Can you confirm to this committee if you remember who she was referring to?
I wouldn't confirm, Honorable Gondwe, because the accessing of the SCs or even any legal assistance by us as investigators is done via the legal services within the office, and they will be the ones who know as to which SC is available at what time. So I wouldn't have known which one she was referring to particularly here.
Oh, but you knew she was referring to a senior counsel. Is that what
To
you're saying?
SC, yes.
Okay. And why did you agree if you didn't know who she was referring to?
Because it's in the normal course of our investigation to use our legal services to access and assist the investigation teams in accessing the SCs or the attorney's assistants. That's what I said. So as to who it was going to be, it was not for me, because we've got a panel of attorneys, I think, on our database from where legal services source the assistance they want for us as investigators.
So you just, and then why did you agree? I'm not sorry, I didn't quite understand why you agreed.
I was agreeing because of the level of what we thought needed to be done, and the PP suggestion, I was agreeing to that. But as to who it was going to be, I didn't know, and it was not for me to know, because we've got several people on our database that legal services normally source for investigators to assist us with opinions.
And can you confirm to us what needed to be done around the Bosasa report by the SC?
I think there was a question about the jurisdiction and the applicability of the code to the deputy president as against the president at the time as a member of parliament. Yes, that was the question that needed to be addressed, I think.
Okay, and in order for the SC to do that, they needed a copy of the draft report.
No, it means then I'm talking about a wrong request here, because when Bosasa investigation Honorable Gondwe started, we also sought legal opinion on jurisdiction. So it means this one, it was for the report that was already advanced. Then it's something else. Then I am correcting myself in that regard.
So you can't recall what that something else is? Mataboge, are you there?
I think that's something else. That's something else is there in the PP's draft. I mean, email to say the draft needs to be discussed or engaged with the SC. I think the gist is there.
All right. No, thank you. That's
What
all from me.
particularly I can't see what particularly needed to be addressed at the time.
All right. Ke lebogile Mataboge.
Ke lebohile nna Honorable Bondo.
Thank you, Honorable Maneli.
Thank you, Honorable Chair.
Chairperson.
Just pause, Honorable Maneli, Advocate Mpofu.
No, Chair, just to assist members for the record, I didn't want to be accused of suggesting answers to the witness, but the email that has just been put, the one previously, it in its heading says that it refers to BBND report, whatever that is, because the witness wasn't sure. I'm just saying for the record, it speaks for itself. Yeah.
Thank you, Honorable Mpofu. Ms. Honorable Maneli.
Thank you, Honorable Chair. Good afternoon, Mr. Mataboge.
Afternoon, that Maneli.
Just a few questions, Chair, to clarify my notes here. It became apparent from direct evidence that there may be oversights in the course of investigations, as you called it, oversight. In hindsight, one would want to check whether this would have then affected yourself and the PP, and I'm saying the PP in the sense that the final layer on the quality assurance is the PP. That your due diligence, your skills, including the conclusions that you arrive at, and finally the report, whether it is the report that you are to take out from the PP side, or even in preparation of your Rule 5.3 as you prepare for courts. So that's what I want to check with Mr. Mataboge through you, Chair.
Did you get that?
Got it.
I got that. I thought Honorable Maneli was still going to pose a question, but I only had him talk about oversight. Oversight in which sense, meaning supervision or overlooking certain parts. I didn't get.
Okay. Let me ask him to briefly repeat that.
I'll repeat, Chair. I started by a statement which in a way should be also confirmed by him. I said, I'm correcting my notes. He called it oversight. And I take it that that refers to omissions in this case, not an accountability mechanism. So that's a starting point. And having said that, that happens in the course of an investigation. Now, the question therefore is, in hindsight, do you also see this as having affected the work you needed to do in terms of due diligence, the skills that you apply, the conclusions to the reports? And as I said, that conclusion, I take it to be also on the reports that are from the PP as you are involved, or including in your preparations for your Rule 5.3. And I've indicated both PP and yourself in the sense that the PP is the final person in the quality assurance. So that's the question, whether from that oversight, in hindsight now, whether you would come to that point that it may have affected your due diligence and everything else. Thank you, Chair. Through you.
Yes, Honorable Maneli, I think to a certain extent I concede, but that would be based on the capacity and the pressures that come with the work. But that doesn't mean in everything that we do, the oversight that I refer to would apply, because there are many other reports. It's unfortunate that we're dealing with 4 now that are part of, or 4 or 5 that are part of the Section 194. But notwithstanding the 4, there are other reports that we wrote that due diligence, in my view, and thorough, supervision, and went into it, or into those reports. But further, I think it doesn't necessarily mean that once the report is being reviewed and set aside, like it happened with most of them, it would be at the heart of the quality, because 1 or 2 reports were set aside on procedural issues other than the content itself. The court did not even go into the merits and the content, if I recall. But your point is taken that because of capacity, we sometimes work under a lot of pressure to turn around to meet the turnaround times. Honorable Manili, yes. But notwithstanding, that should not be used as an excuse for us to then have this oversight. And I'm happy that we're talking about it in hindsight now. Thank you.
Thank you, Chair. If I may then proceed from that line. The CR17 report, including the SARS unit report, are major reports that you were the chief investigator reporting directly to the PP. And the court, in setting aside these reports, raised significant shortcomings in the reports. I think then the question that arises, and I'm linking this question to an answer that I listened to, which I would verify. Was there any consequence management that was introduced after this?
No, there was no consequence management introduced.
Of course, with the other witnesses who have come before us through you, Chair, there were also issues about how the letters that get received, and in that interaction, Mr. Mataboge would have indicated 2 things on Advocate Bauer's questions. It was like that he would have heard from corridors. Should I then assume to be correct evidence on your side that you've never received at any given time an Audi letter? Secondly,
no,
okay, but secondly, also informed by your response to Advocate Mpofu's question about disciplinary, whether in the course of doing your work you were faced by disciplinary measures taken against you, and you said in that case, no. So I just want to check, as it relates to Audi letters, whether you've ever received Audi letters in that score.
Yes, Honorable Mandela, I've received, I think, 2 Audi letters, but all of which would relate to the work in general, not particularly to SASA or to SARS. They would relate to the work in general, the fact that we don't meet targets, we don't deliver on the dates that we agreed with the public protector and so forth. I think as a chief investigator, I would not have escaped that myself.
No, Chair, I'm happy with this response that he was not excluded from Audi letters, but they do not relate to these matters. And therefore, my last question in that regard, just to build on what Honorable Gondwe would have raised about lawful instruction. There is an email that we also saw, which one would regard it as an instruction to consider a report from Mr. Madiba. And your response, Mr. Mataboge, was that once you would have received the email, you did not act on that matter. If I were to use your words, you said it may come as its subordination. it's unless I didn't hear you well. I was trying to take rigorous notes, but it was not as you tried to explain it. But that's a lawful instruction, and it also came out in the, I think, Rule 5.3, that instruction, that there was lack thereof. Now, I just want to check, would you indeed regard defying a lawful instruction as insubordination, which necessitates consequence management?
Yes, I would, Honorable Manil, but I would have to explain myself to my executive authority as to why I would not take instruction. What's my way of thinking? I would not just disregard the instruction without explaining myself as to the line. That's why I even said to the committee that my take, which is still what I stand by today, is that I didn't want the narrative or whether of Freire one or the Madiba's report to influence my subsequent or after my own assessment of the investigation that I would have conducted independently, and his narrative to influence on how I come to my conclusions. And this is what I even said to the then COO who was then there, who's no longer with us. That's why I was taking that line.
No, thank you, Chair. Thank you, Mr. Mataboge.
Okay.
Thank you, Honorable Manili.
Thank you, Honorable Manili. The last person to engage will be Honorable Dlagode.
Thank you very much, Honorable Chairperson. I won't waste the time of this committee. My questions were covered, but mainly by Honorable Maneli and Honorable Gondwe. Thank you very much.
Okay. Thank you very much, Honorable Dlagode, for the discipline not to repeat questions. With that, therefore, that concludes the interaction of members with Mr. Mataboge. I now go back to Advocate Mpofu if they are, Advocate Bauer, no, Advocate Bauer, if she has any pickup questions that she, and
No,
whilst I was inviting members, you were saying something. It is now your opportunity, so that.
Chair, I as you will recall, I didn't question Mr. Mataboge in depth on the Busasa report. I plan to do it in writing. When I got back and I looked at my notes on the way he answered it, I was happy that he covered it. But yesterday, good afternoon, Mr. Mataboge.
Afternoon, Advocate Bauer.
He answered certain questions of Advocate Mpofu that I do need to clarify, and in order for it to make sense to the committee. Unfortunately, I have to do that in the context of the documents. And I want to deal with the proposition that was put to Advocate Mataboge yesterday, that for the PP to have any, and I think I want to use, I think scheme or specifically target any person. What was the word you used? Vendetta. She would have had to have recruited the investigators to do so in the context of the investigation. Is that, and you said you agreed with that. Did I understand you correctly?
I don't recall that.
Let me see, let me rephrase this. Advocate Mpofu said in the context of having to make a finding or to come to the conclusion that the public protector focused or had a scheme or targeted or had a vendetta against, I think it was in the context of Minister Gordhan, for her to be able to do so, she would have had to have recruited her investigators in being able to pull something like that off. And you disavowed having been recruited in such a manner.
Yes, but I would not have been, as a professional, I would not even be, a subject or be liable or possible to can recruit, in that context. having been working here for so long, I would not sacrifice my integrity and image just for one situation on one report, if I may use the word.
I understand that. And I want to take you through, in this case, I did this exercise in respect of the SARS unit report with Ms. Mkhwebane, but you are essentially the investigator in the Busasa matter, and you report directly to the PP in that regard. So I want to take you through the draft 7/9s in sequence and context, just to understand something. I am correct in understanding that you are you wear the hat of the investigator in the Busasa matter. Am I correct?
Yes, you're correct.
Right, and you answer directly to the PP in respect thereof.
Yes.
Right. Now, can I ask you, when you're the investigator in the matter, who do you then rely on to check the applicable legislation? Do you do it yourself, or you dish it out to somebody else in your unit?
I work with the teams. I also use legal services as a sounding board.
Now, in the Busasa matter, we must talk about teams very carefully, because we're told that we had a lean communication channel to prevent leaks. So when you checked legislation in the Busasa matter, who actually did it?
I think this one was being done in conjunction with our legal services. That is why even in the beginning I said, before we started with the investigation, I think legal services had to seek legal opinion on our jurisdiction on that. So we work closely with legal services.
Did you, as the investigator, independently verify the legislation?
Yes, I did.
Okay, so let me take you to, it will be bundle 194, and it's page 6560. Now, this will be what the members will see to be the report which you prepare. Sorry, let's go to the first page, which would be 6554, so that we can see the context of it. Okay. This is one of the early drafts. I have not tracked an earlier draft, and if you go down, you see, just go down a little bit. You tell the PP, kindly receive rough draft section 7/9 as discussed for further guidance and directive. Would I be correct in saying this was probably one of the very early drafts, if not the very first one?
Yeah, this one would have been the very first one, I think.
Okay, so then let's go up. Now, up is that way and down is that way, right? She then comes back to you not long after that, find attached and see my comments, right? Now, if we go just down, Seppo. We've got down, right?
Chairperson.
Okay.
Sorry, Chairperson.
Yes, Advocate Mpofu.
Thank you, Chairperson. Yeah, I hear we have a new person operating IT. I thought it was Chapo.
Advocate Mpofu,
no, thank you.
I've been chastised from day one about names. Don't go there.
Okay,
I have been. Okay. I can't remember anymore. I've been told that I even get the Honorable Milam's name wrong. So half the time, my team has been on me from the start. So let's not take that.
No, thank you. No, so that was on a lighter note. Chairperson, I want to. I don't want to be difficult, because we're all trying to search for the truth here. But I just want to warn Advocate Bauer not to overdo what she's doing. I'm not stopping her, but she can't raise new issues. I discussed this with her in the morning. She can't raise new issues at this stage because for two reasons. One is, you'll remember that last week I was at pains, and as I was saying earlier, I even asked for her to get extra time because I realized that she had not covered some of the reports. And it was and she still didn't do so. She went on about Mr. Kotan and the rogue unit and all that. And it was to prevent something like this. That's number one. The reason for that, Chair, is that if she raises new issues in what is effectively re-examination, then I have to exercise my right to cross-examination, and then we'll be here all afternoon. So I don't want us to get there. I'm just saying I can understand if maybe because of time, she did not get to certain issues. But thirdly, Chairperson, which is more serious, why she should not be allowed to do this ordinarily, but if you want to be lenient, I don't mind, is that you as Chairperson, then when eventually we did run out of time because the witness had to leave, extended the opportunity to Advocate Bauer to ask whatever remaining questions in writing last week by Friday, which should have been responded to by Monday on the issues that she had not managed to cover. She did not exercise that right. She did not ask those questions. And in which case we would have had access to the questions and the answers, and then I would have covered that in my cross-examination. So to now try and exercise that right through the back door in re-examination is just unfair and incorrect. And as I say, I'm not saying she must stop if there are issues of clarity. I don't want to be fastidious about that. But if it goes too far, I'll then have to intervene, Chair, or exercise my right to cross-examination, which will just defeat even the purposes of trying to finish early. Thank you.
Thank you, Advocate Mpofu. Advocate Bauer.
Chairperson.
Yes, Mr. Mataboge.
I wanted to talk before Advocate Mpofu talk on the same matter, to say I'm surprised now that I don't know, I'm not that good with legality, that I seem to feel like I'm now suffering double jeopardy. In that Advocate Bauer last week said to me she was going to send me questions, and I must in the meantime send her documents, which I did in many Mimecast because they were voluminous. And on the back of that, I got a call from Ms. Ibrahim to say I must now be rest assured that there won't be any further questions being sent to me, because what I've sent through to Advocate Bauer is sufficient and addresses what she wanted to ask on questions. So for me to be taken through her questioning again, it's like now, it's another session of her leading evidence against me. And I don't know, because this is not a court of law, would I then be able to be correct to cite double jeopardy? Because I don't want to refuse to answer questions, because I've been cooperative, and even though I sometimes feel like I'm being pushed overboard by the committee and the whole process itself. Thank you, Chairperson.
Okay, maybe just for your clarity before I go back to Advocate Bauer, I would have recognized her based on our directives that we have, and I'll try and just summarize for you. I've utilized the directive 6.16, which says after members have posed questions, the evidence leaders may ask, and they have a discretion therefore, may ask any questions arising or seek clarity from the witness in relation to questions posed to such witness, whereafter the chairperson shall excuse the witness from the hearing. So she is on that platform. Advocate Mpofu was raising a different matter than you, but I hope you're not surprised that she's coming back, because that's how we do it. But I'm now going to give Advocate Bauer to respond to the issues.
Mr. Mataboge, when I asked you the question, and I put to you that as far as I was concerned on the documentation, that you had actually gotten paragraph 2.3 of the Executive Members Code correct. That as far as I was concerned, you hadn't made a mistake in your documentation on that. You then in cross-examination with Advocate Mpofu agreed on the deliberate and inadvertent interpretation of it. I could not have asked you these questions on Sunday when you only got cross-examined by Advocate Mpofu thereafter. I had, on my understanding, accepted that you had accepted that you had gotten it right. And so now I want to actually point out to you that you had gotten it right in your draft and show you where it actually got changed and how it actually got changed. And that is directly arising on the difference of the version that was given, as I understood it, after I had finished with you last week, and what arose in cross-examination. Now, I could conceivably not have asked you that over the weekend.
No.
Do you want to? I wanted to proceed, but Advocate
Yes.
Mpofu?
No, I'm sorry, Chair. I was also hoping that this is not going to take long, but I can't allow this to be said now like this. Advocate Bauer last week, when she did actually, probably the only thing she questioned Mr. Mataboge on regarding Busasa was this point about the code, because according to her, she said that was the only issue, which, well, we'll deal with that when we are in argument. So to suggest that it was only provoked by the cross-examination is not correct. But secondly, as you correctly say, Chair, and just to support you in respect of Mr. Mataboge's concern, that what I was raising was not the mere fact of Advocate Bauer raising any questions, because she's entitled to do so. I did it with Ms. Mkhwebane as well yesterday or the other day. But it was the content, as you correctly pointed out. Again, I don't want to waste time with this. I'm simply saying, I'm not even saying the question must not be asked. I'm simply saying she must just watch and not bring new material, which will then provoke the right to a cross-examine. Thanks.
Thank you, Advocate Mpofu. Advocate Bauer, over to you. Just put your mic on.
Sorry, I want to go through it very quickly. I'm going to let Shepherd do searches. And yes, I do not do justice to her name every second day. We accept that. And see if we can do it via searches to go quicker. So if we go to page, I'm alive to the fact that there's a flight waiting, Advocate Mpofu. 190.4.
No, it's not about the flight.
5, 6 hours.
I don't have to respond. We've never spoken about a flight here.
Okay,
So don't respond.
Sorry, Chair.
Right. So Mr. Mataboge, this was the initial version, and I'm going to let our operator behind me do the search for the word willful. Yeah, just do a Control F, yeah, willful, WILFUL. Right.
So, while she does that, I suggest that we also go to the emails I used on, I think, Sunday, to send through the documents that I was sending, because I was answering and commenting on each document that I was sending. I think I also commented on the inclusion or non-inclusion or exclusion of the willful versus inadvertent in the email that I sent through to Ms. Ibrahim, and I think it's Tepo. That email may also shed some light.
Sorry, Mr. Mataboge, I got documents, but I didn't get comments from you. I only got documents.
Yes, I'm aware. That's what I'm saying. When I was trying to send them through to the officials, that is Ms. Ibrahim and others, because of the server size, they could not go through. Then I had to send them through Mimecast, because only your Gmail was able to take the volume of documents that I was sending through. But attached to, I mean, these volumes of documents were accompanied by emails and paragraphs in which I was answering each question and clarifying each question that had been posted in the letter.
Spelling.
Advocate Mpofu?
No, this is a quick one. I want to help. The reason why your word search is not working is because you misspelled willful. It says 1 L.
You want something else? Okay.
Yeah, that's it. So just to clarify, Mr. Mataboge, I got the following. arising from the exchange over the weekend. And we must maybe clarify that, because if I have it, then that's what Advocate Mpofu has as well. And if there's something missing, then we need to get to the bottom of that. I got an email from you, which was dated let's just check, which related to a draft answering affidavit in the National Assembly matter. I got a few pages of the investigative diary, but not the investigation plan. I got a few Word documents listing, a Word document listing the documents which Ms. Mbuyana received as part of her investigation file. Then I got 3, 6, 8, 10, 12, 14, 16, 18, about 20 memos, which is like a route form going up to the public protector in respect of the Busasa matter, and different letters and stuff that went out. One, to my recollection, relates to the SARS unit matter. And then I got 3 closing reports which related to the Pravin Gordhan matters, all of which is signed off by the acting public protector as closing reports currently, not by Advocate Mkhwebane. They're not signed off by her, but I'll ask you that question when I get to it, because it might have been signed off by her, but actually dealt with the, right? And then the other documents I got is, which we've got under what we would know as 190.6, which is 3 draft final reports of the 11th, the 12th, the 15th, and the ministerial handbook that you've provided as that. I'm not going to the reports and the handbook. I'm going to the first draft of the section 7.9, which you submitted to the public protector much earlier, and which had been given to us in the first batch of documents when we had made the inquiry last year already. Is there anything else that you had given to us that I have missed, Advocate Mr. Mataboge?
Yes, you've Advocate Bao, you've missed the emails explaining the documents that I was submitting, because in submission of those documents, I was answering sequentially the questions that have been posed in the letter, and then attaching documents to support what I was answering on, I think. That is why I say the issue around EMIA and the Executive Ethics Code is also captured in the email that I sent through before I could send those drafts and the handbook by Mimecast. I had sent an email through to Ms. Ibrahim, to Tsep, I think to Mr. Ngoma, I swear if I'm correct, but I had sent emails answering each question or addressing each question in the letter.
I missed it, but this is not the answer that I'm actually going for. So can we just answer the questions I'm going to put to you, and you can then refer to this if you'd like to, but this isn't where I'm going, Mr. Mataboge.
It's fine, it's fine.
Okay.
It's fine.
But it might well be that in the flurry of documents and us wanting to make sure that Advocate Mpofu got it timeously, that the actual body of the email got missed somewhere on our team. But I'm not sure about that right now.
Chair.
Yes,
no, I think I can confirm that my documents seem to correspond exactly with those of Advocate Bauer, except in one respect, that the closing reports, the 3 closing reports, unlike what she says, only one was signed by Advocate Kaleka, the other 2 were signed by Advocate Mkhwebane, but the actual documents are the same. Thank you.
Okay, thank you for clarity. Thank you. Over to you, Advocate Bauer.
So I think Advocate Mpofu, in the email body, which I'm just being shown now, Mr. Mataboge answered some questions. and I could have missed it. We had a problem in that documents were too big for Parliament's email, and I tried to assist them. But let us, in the interest of saving time, Mr. Mataboge, could we just do it in the way that I'm suggesting? And if there was something that was missed, we could then just deal with it in this way.
Yes, no problem.
So if we could go back to the page and we'll spell willful, W-I-L-F-U-L. Right. So if you see in paragraph 7.3 of your draft, you correctly cite the Executive Ethics Code. If you go down to the next paragraph, if you search it, just please click next, go down. You'll see in paragraph 9.18, you correctly refer to it. In the next paragraph, 2.3, you correctly refer to it. And if we, but the documents are continuous. I don't want to go out of the document, but let's go to the next one. Are you back to the top now? No, okay, go back down. Wait, hold on. I think you're on the next document. Right. So if you go to page 6579 would be the last one on that document, right? And then if you go to page 6571, right, you'll see that what the public protector does is she puts comments in the document and she says, include the legal provisions from the legal opinion, also include the Concord judgment on how the president should conduct himself. You see that?
Yes, I do.
Okay, if you go to 6579, if you go down, you get the same instruction to put in the legal opinion and the reference that he met these people at dinner, right, to do this. Now, you testified to us, and I took you to it about the legal opinion that had been provided by Mr. Sienego, correct? In respect of the Busasa matter. You referred to it earlier on, also as the one in which advice had been rendered on jurisdiction, right? Now, you know you would be aware, even though you're not legal services, your client would request the legal opinion from the attorney. The attorney would then give an instruction to the SC or the council or whoever, and then an opinion would come back. Correct?
Yes, but I'm not legal services.
No, you're not legal services, but you know that that's how it's done. If you want an opinion, you go to legal services. Legal services would get authorization. They would then go to whichever attorney is on the books. That attorney would then get a legal opinion from whichever council you guys use at the PP's office. That would not be you that get the opinion. It would be legal services.
Yes.
Right. But you are provided with this opinion in the context of the Busasa investigation.
Yes.
Right. Right. Now that opinion, if we go to page, it would be bundle F96 at 123129. Right. Okay. And if you go down to paragraph 3.2. Okay, go up. I just want to take you to a few places in the opinion, 3.2.3. Go up. Go up. Sorry, just hold on a sec. Yeah, let's just run through this opinion. Just start at 120. I had given a guide, and now we're getting let's just take you get this opinion that comes in. Let's just go to page 120 on the opinion. I'll do the same, and then we're on the same page on it, because it would be easier for us to do that. Right, go down to the next page. What's the next page that you have? The next page you have should be, no, you must go to 129. Right? The opinion tells you about the risk of being repetitive. No legislation requires systematic and proactive disclosure of private funding of political parties, i.e. the ANC. Consequently, political parties are under no express legal obligation to disclose the source of their private funding at elections or other times. On the contrary, different considerations apply when it comes to individual ANC members who may be members of parliament and cabinet members at the same time. No matter how one frames the issue, a conclusion that direct sponsorship of one's political campaign for party leadership does qualify as declarable sponsorship is unavoidable. And so likewise, the 500,000 gift to the CR17 campaign was a disguised gift to assist the president's individual campaign to win the political party presidency. It is significant that the ANC has no rules governing direct funding of party members vying for the ANC presidency. So you get that goes on, and then it tells you how it must be disclosed and that it's a gift. And if you go to 3.3.3, which is 130, you see our answer to this question is that the president cannot rely on party political activity where the rules of the party he is a member of do not permit him or specifically restrict funding of political campaigns by its members aspiring for leadership ascendancy. Do you see that, Mr. Mataboge?
Yes, I do agree.
Okay, we then go on, it goes on and it says, it looks at 3.4.7. And it goes down, looks at what's in good faith, 3.4.7.
Chairperson.
I'm just looking for one paragraph.
Okay,
just bear with me for a second.
he's talking to the chairperson. Wait,
Yes,
wait.
yes.
We don't know what he's going to say. Advocate Mbofu?
Yeah, absolutely.
You're not
Thank-
saying that. Eh?
No, I'm definitely not saying that.
Okay.
I wanted to, maybe I missed it. Is it, whatever the basis of the question is it that this witness knows about this opinion, read it, asked for it, solicited it, or what? What is the connection between him and the opinion?
Okay. Over to you, Wilbao.
Mr. Mataboge, you prepare a draft, right? You then told by the public protector in elaborating on the draft to go to this opinion. Is that correct?
That's correct.
Right. So the paragraph I'm actually looking for to save time is right at the bottom of 2123.135. 2123.1.135. Right. Yeah. Right. And there you see quoted paragraph 2.3, go down. Here you see the introduction of members may not deliberately or inadvertently mislead the president or the premier, as the case may be, the legislature. So where is your section 7.9 document correctly referred to section 2.3? The legal opinion refers to it incorrectly. Do you see that?
Yes, I see it, but isn't it in the section 7.9 itself? This opinion now, isn't it not inserted now at this stage?
It's not inserted yet. Let's just go. Your version that I gave you is, as I took you to the 3 paragraphs, has got the 2.3 correctly. You get an instruction from the PP to insert from this opinion, right? And she tells you what of this opinion to insert. So let's go to the next version of the opinion that you then produce, which you then see at 6571 para 9.1.23. And we know that the person with the yellow highlights is quite distinctive in the document. Yes.
Yes.
Right. So we see that there is where you told legal opinion must come in. Now you go to to the next draft, which is 6599. Yeah. Right. You still told that you insert paragraph, hold on, 9.1.24 gets inserted, which is not there in the previous paragraph. Go up. In the absence of explicit rules dealing with the corrections or amendments, regard must then be had to section 2.3 of the code, which states that members not deliberately or inadvertently mislead the president or the premier, or in this case, the legislature. And so introduced into your section 7.9 for the first time is a different version of the executive ethics code, because you had the instruction to take the provisions from the legal opinion. Now, if you go to 6579, did you realize that you were inserting a different version, Mr. Mataboge?
I wouldn't say I realized, because like I said to you, Baba, this was the one that we had used in the previous report. I know you said two wrong, don't make it right. But I think for me, it was more like you are correcting the one that had been initially put, the one that comes from the code itself, not from the ministerial handbook, this one.
But Mr. Mataboge, you were using the one from the code and not the ministerial handbook. It is in your 7.9, and in fact, it's in your report in the final version as well. So I just take it to the logical conclusion of where I'm going. Go to paragraph 9.3.8. I'm not talking about the two wrongs make a right. Just we've been through that. I'm not going back to that, right? Paragraph 9.938. You told again, use the legal opinion for further information in that regard. On the second draft at 6615, right? You go to paragraph 9.3.4.23, right? Based on above, I do not believe that in this matter I failed in my duties to disclose interest as required in the Executive Ethics Code. There's a draft, and you again told, put in the legal opinion, right? In the PP's comments, she also tells you to go find facts in the legal opinion. Now, if you, which is, if you go to paragraphs 9, right? And then if you go to the document on the 15th of May, which is the next draft, 6621. I must go, if it's not the first page of the email, I must take you to the first. Okay, there we go. It comes back on the 15th of May. Thanks, Mataboge. Check the few comments, attach the movement of money. Johan to assist you tomorrow with the total transfer to reattend the Environ for a Ramaphosa Foundation. I'm happy with the draft. Finalize it tomorrow for my signature. Do you have the draft from Njibolo? Share with me so that we cannot finalize it tomorrow also. That's a different version. Can you see that?
Yes, I do.
She's talking about the EMEA, and then she talks about the 214 version as well, right? Now, if you go to page 6651, right, which then takes you to 9.1.2, there we go, right? This is what you then insert, okay?
Yes.
And you put in the table of disbursements, which you must still come, and then you put in the application of the relevant legal prescripts, which the public protector told you to take from the opinion, and you take the Prevention and Combating of Corrupt Activities Act, and you quote it, and you go down. We're not going to deal with the content of it. You deal with what the provisions tell you, and you introduce the money laundering aspect based on this act. And you go down, right? And then you come to the conclusion that based on the facts before me, I'm therefore of the view that there is merit to the allegation relating to the suspicion of money laundering as alluded to in the complaint lodged with my office, right? So you inserted that with a law that emanated from the legal opinion that was provided, correct?
Yes, correct.
Right. And that law that you refer to is what a lawyer would call PRECA, but you call it PACA in the opinion. It is not POCA that actually refers to money laundering. The courts actually tell you that you use the wrong act. Isn't that so?
Yes.
Right. So if you then go to 9.3.16, which is at 6661. 9.3.16. Right. You then insert the applicable case law as you were told to take out of the opinion to do, and you insert that. Now, if we go to the email on the 16th of May, which is 6665, right? You tell the PP, I tried my best to incorporate the information. Madam, if it's possible, a pair of few new extra eyes would assist in the final product if we had QA. Do you see that?
Yes.
Did that happen, Mr. Mataboge?
Yes, I think it did, but in a narrower, I think the people who were closer to the investigation, maybe the chief of staff and then the people who were closer to, because it did not just end up with me and then the PP. You know, there were other people in the closer circle that also had to have extra eyes on the report. Yes.
And did you get feedback from any of them? Because I have not been provided with one email from any other person having given input into the Busasa report from the PP's office. Not the chief of staff and not anybody else.
I don't think it would have been in the form of emails, maybe in meetings, because even when we went to deliver the 7-9 at the president's offices, we were with the EM, the COO, and even the chief of staff. I believe that those people would not have just accompanied us, carrying a document that they did not have sight of, or even make comments or input on. They may have participated in meetings.
They provided affidavits to the committee that said they did not.
All right, if that's what they are saying, with Bauer, there's nothing I can follow them for or say.
Did the visit to the,
sorry?
Sorry, didn't the visit to the president's office precede the 7-9s?
No, when we went to deliver the 7-9, it had been long discussed with the team that was senior. I remember even when we agreed that because of protocol, it needs to be delivered. The COO and the chief of staff and all of those people were all agreeable. That's what I'm saying. Would they have agreed to go in and be part of a meeting where PP would present their 7-9 in which they had not participated or even had sight of? I'm just wondering.
I reiterate, I haven't seen any input, but be that as it may, let's go to 6-7-11. Right. This is just where you tell her I've moved documents around, paragraphs around. I haven't changed anything in the document. I'm just showing you that for completion. So let's go to the next version, which is 6575. Right? Is that 6575? This is where she gives you further instructions on what to put in. And then if you go to 6917, you give attach the final, I think we have several final drafts, but this is one of the final drafts with new inputs into 1.35 and 36 and 920. Now, if you go to 6936, And here you see this has been changed in respect of, consequently, President Ramaphosa's reply was in breach of the provisions of 23A, the standard of which includes deliberately and inadvertently misleading the legislature. In fact, here it reads inadvertently, deliberately misled Parliament, in that he should be allowed himself sufficient time to research on a well-informed response. His conduct referred to above is inconsistent with his office as a member of cabinet. So here you see where it is actually being introduced again. You see that, Mr. Mataboge?
Yes, I do. Yes, I do.
Right. Now you go to 6994. And you see the conclusion is then put in on the failure to disclose financial interest which accrues to him as a result of the donations constitutes a violation of paragraph 2 of the Executive Ethics Code and amounts to conduct inconsistent with his office as a member of cabinet. Right. Now, there's then 1 or 2 further versions, the 29th of May, which is 7011. You put in further inputs at 9137029. That goes with it. 70299133. There are minor editorial changes of grammar or something like that that I'm not, sorry, 7029. Right. And if you go to 9.1.33, you then introduce the paragraph relating to the rumors of the relationship. And then if you go to 7056, you come to the beginning of the adverse findings in respect of having regard to the evidence received, the regulatory framework that President Ramaphosa should have compiled with and the impact it had. I'm likely to make the following adverse findings against the president, right? And then if you go to 7061, she tells you, tell her, I've added a new paragraph 9.1.37 to address the point raised by you in reference to the Concord judgment for your correction. And you then go to page 7080. Right, paragraph 9.1.37, as head of state and the epitome of the Constitution should have acted with restraint and not allowed Mr. Maimani's question to affect his demeanor, as he had stated in his response that he felt attacked and had to defend his family. Right. And then if you go to 7.11, I'll pose the question at the end of it just to save time. 7.11. Before Advocate Mpofu asked me, where's the question? Right?
Yes. We don't want soliloquies here.
Yeah, it's soliloquies. You then say to her, Madam, I've incorporated all the new yellow text as per the memo on the notice. What memo is that?
The memo would relate to when we submit the notice. The memo is what we process as part of the submission to the PP, but it goes through the approval lines. So the memo is normally accompanying the notice or the report or the subpoena draft. So that's what the memo have been about here.
Okay, and would that have been one of the memos that you provided to me?
Yes, because then the memo would have all the signatories within the office that need to see the report or the draft before it goes to the PP.
Right, but this is the Busasa matter. Your evidence was that nobody was actually dealing with the drafts other than you and the PP.
I didn't actually say that. That's why in the memos that I submitted, I tried to show that when my managers were saying they were never involved, I even have some of the memos relating to Busasa in that batch that I sent, if I remember correctly. Because I still have to submit in terms of protocol or channels through my manager. except where people would then have sent me an email wanting it, give me a direct instruction. But submission of document, you still have to follow normal process and procedure.
You see, Mr. Mataboge, all the memos that you give me relates to either getting a letter signed or a subpoena done. None of the memos that you provided to us that I looked at in the 14 or so memos that you gave me actually deals with the substance of any of the reports. It's where you request.
Is there no one related to the notice?
Let me just check. There is one. No. You ask for approvals to FIC, you ask for to sign letters to the president's legal advisor. None of these memos that you provided to us, and I have to go past May 2019 because that's when you provided the first draft. Not one of the memos relate to that. And as far as the SARS unit refers, the only memo relates to the issuing of the subpoenas in respect of the 3 tax people. And you know that the provision of the memos to us arose in the context of where I asked you for documentation to show that in the chain of command to which you referred, the EMs and the COO, that they had involvement in respect of the SARS unit report. And you said they did in respect of the SARS unit report, but not in respect of the Busasa report. And that you had memos to prove it. And not one of the memos that you had provided to us actually proves that any of the EMs or the CAO had any involvement in the compilation of the SARS unit report. And that was corroborated by Advocate Ms. Mvuyana's evidence. And in fact, on the Busasa matter, your evidence had been they had no involvement. It was between you and the public protector. So when I ask you,
That's
do
why,
I?
that's why
Sorry.
I say on this.
Sorry, Mr. Mataboge, finish.
I wanted to say, that's why I say on the strength of the mention of a memo there to the notice, I need to find out what memo was I referring to there, because the memo would have been accompanying a notice. Notice is a 7-9 notice.
You see, Mr. Mataboge, the email on the face of it at 7111 says you've been provided with a memo, and based on that memo, you've put changes into the document. But let's just go back there, Shepo, and just look at, I've incorporated all the text. So let's go to 7130 to see what you've incorporated. Because we guided by the yellow line. So we see that now based on this memo that's provided to you, you then put in changes that says he inadvertently and or deliberately misled Parliament in that he should have allowed himself sufficient time to consider the question and make a well-informed response. And then at 7160, you've invited the President to state under oath that he had declared or provided your office all the relevant information. Do you usually ask that of somebody who appears to provide you with an affidavit that they've given you everything?
Mr. Mataboge, are you with us? You muted, Mr. Mataboge?
Sorry, Chair, I'm muted. I wanted to say this paragraph that then. Yes,
Go
I
ahead,
wanted
go
to say
ahead.
this paragraph. Yeah, this paragraph, much as it's highlighted in yellow, like I said earlier on, to say sometimes I'll highlight it in yellow, but it would be based on the discussion we would have had, not necessarily that it comes from me. And if I recall, this particular one paragraph was as a suggestion from Ms. Basani Valoi, that paragraph 2022. So that's why I say it doesn't have necessarily should have been from emails exchange and things that are tangible. It would be in meetings that may not even have been recorded, as far as I recall with this one now.
You see, Mr. Mataboge, when we asked you in direct evidence who was involved in the compilation of the reports, you in the Busasa matter, you said it was you and the public protector. Is that not correct in the direct evidence? That's what you said to me last time.
That is correct, but it doesn't mean that there were no inputs and what do I call it? I think inputs or even suggestions from other team members. That's why I even said that the fact that we went with the team members to submit the 7-9 to the president, those members would have also participated in the meeting in preparation for the submission of the 7-9. And for me, as professionals, they've really submitted and accompanied the PP without having participated at all in the document that was being delivered.
So it actually defeats the purpose if the question is we making a lean team and we exclude certain people and then we bring them back into the fold. They actually, that can't then be the reason why the team is lean, because you do actually then have meetings which includes the CEO and the EM on what you're now telling me.
Yes, that's why I'm not privy to other, because I'm a junior to the EMs and the CEO. I'm not privy to other engagement that was subsequent to my submission that the PP may have had with the EM or the COO or even the chief of staff or himself. That would then come to me as part of what I need to incorporate, because they don't need to meet necessarily in my presence.
So let me take you, I've just got 3 more references and then I want to ask you something. 7161, which is the version of the 30th of May. Right? I'm done, madam. The changes are on pages and you tell her where the changes are. And then let's just go to 7190. You've elaborated on the hosting of dinners and it's 7199. Mr. Watson confirmed, although he didn't attend all the dinners, he was present at the one hosted. Okay. And then 7202. Now, Mr. Mataboge, you get told what to put into the report into the 7-9 after you furnished it, correct?
It's being told or getting inputs, which is not unusual.
And the 7-9 is signed off by the public protector afterwards, correct?
That's correct.
And ultimately, she is responsible for both the 7-9 and the report.
Yes.
Right. And she tells you to go and take information out of a legal opinion. And you do that.
Yes. That's why I'm saying it's not unusual.
Right. And it is unusual for a legal opinion to be provided by one person and to be furnished to the public protector under the name of another. Wouldn't that be the case?
No comment on that.
The general proposition. Okay. Then if I can just take you to 190.5, which is the memos and the closing reports that was provided by you. I want to take you to the first one. If you go to the, let's go to 7472. You see the signature there?
Yes, I do.
Okay, that's the acting PP signature. Correct?
That is correct. Yes.
Right. And as just so that there's no dispute between myself and Advocate Mpofu afterwards, you'll see that at 7414. Yep. Go down. Right. That's the signature of Advocate Mkhwebane, correct?
That's correct.
Right. And then if you go to 7472, if you go down, that's the signature of Advocate Galeka. So we actually both wrong, Advocate Mpofu. Right? Just so that we don't mislead the committee, both of us.
Yeah.
To do that. Right? Now, let's just talk about these court papers that goes in. You are involved in the SARS unit matter, the pension Pele matter, and the Busasa matter. And they all get reviewed and they all get set aside. Right? Are you involved? Let's take them one by one because I want to be sure about your evidence. Are you involved in making comments and in settling the affidavits in respect of which filed on behalf of the public protector in the SARS unit matter?
Like I said previously, I would check the legal services would be the one responsible, but they would be asked to consult with me as the investigator of the matter. And where I would have comments, I would make comments, but where I would not have comments or inputs, I would not make inputs.
Right. And
do
you do that in respect of the pension Pele matter?
No, I don't recall. I don't recall then.
Did you give inputs in respect of the Busasa matter?
I don't recall either. I'll have to check my records. But all of them would have been brought to my attention as is practice. To say this is the affidavit, answering affidavit, you make inputs, what are your inputs, you agree, you don't agree.
Mr. Mataboge, if there are mistakes on those affidavits, then those mistakes lie with the deponent or the chief investigator.
Yes, because before it goes to the PP or it has been done by the legal services, and then I check it for correct. I check it for correctness when it comes to facts and issues that I came to know in my investigation. Yes.
So, Mr. Mataboge, that is why I'm asking you whether you check these affidavits. And the reason why I'm asking you that is because, again, I do not have copies of the emails that you are provided with these affidavits, that you are provided with these founding papers, and that you have made comments of any kind to them. And that is why I'm asking you this in respect of those cases. There were extensive litigation that took place, and yet in the documents that we have at our possession, we do not find documents emanating from you in respect thereof. Now, we asked you this question, and only one affidavit came back in respect of the National Assembly matter.
My involvement with power would not necessarily have been on electronic inputs. I would have been with the legal services when they take me through what they have and in their office and reading out what they have prepared. And once or twice, when even the consultation with the attorneys that are assisting the PP, I'll be part of those meetings. It doesn't have to necessarily have been on electronic engagements or submissions like we did or we see now with the 7/9s.
So what is the and does this happen once in respect of the matter? Because there's many drafts that go back and forth with instructions between the legal team and the public protector. Is your input sought once, or is your input sought before the affidavit is signed? At which point are you consulted?
No, at the beginning, when the first answering affidavit is being prepared, and once or twice, even during the continuation of the matters, yes.
If there are errors in those affidavits, where would those errors lie with? the deponent or the investigation team?
I think because the final signatory would be the deponent, that would then be like it's the deponent because she's the one who attests to those things. But it may have been even legal services and the investigator because it starts with them before it goes to the deponent.
Yesterday, and this is the other aspect that I want to move on, Advocate Mpofu took you through paragraphs that deals with emails in which he said you obtained and on which served as the evidence before the public protector. Do you recall that? It was these emails on which you got some of your information from. I think it was either given to you by a whistleblower, if I recall correctly.
Yes.
Do you remember that? Right. Now,
I recall, yes, I do.
Right. Now, in the High Court judgment, the PP identified and referred to these emails in her affidavits, and it's then dealt with in the judgment. And the judgment is bundle C. No, it's number 30. Yes. I think it's number 30. And it would be page 1100 at para 117. Right. 117. While we're looking at that pages, you accept the Mail and Guardian judgment is what is usually followed, correct?
Yes.
Right. So the High Court says in this regard, in her report and answering affidavit, the public protector discredited the president's version on the basis that the leaked emails showed that the evidence was untrue. In her answering affidavit, the public protector identifies the emails she relied upon in discrediting the president's version. They comprise 2 emails sent by Ms. Nicol within the space of 1 week in November 2017. They support the president's explanation of his limited involvement in the fundraising activities in that they show no more than 2 instances in which, among other things, the names of potential donors were discussed with him. These emails do not constitute a sufficient basis for the public protector's rejection of the president's explanation of the CR17 campaign and his involvement. Do you see that?
Yes, I do.
And that's based on what is contained in the public protector's affidavit that she filed in the High Court. Do you disagree with that? That what was relied on was 2 emails based on those dates?
I think I'd rather not comment on that. The people will be able to answer on that.
Now, if you go to the Constitutional Court judgment, and we'll go to the real Constitutional Court judgment, the majority, at page 7, at paragraph 76.
Well, there's only one Constitutional Court judgment.
Yes.
So when
I'm only
others
teasing at
when others got minority, they're looking for something. Thank you.
Chair.
Advocate Mpofu.
Yes, no, the real articulation is that there's one Constitutional Court judgment made up of the majority judgment and the minority judgment, and they're both real. Thank you, Chair.
Let's go to the one that counts in paragraph 76. Isn't that number 18? 16. Concord judgment in Busasa. It's 16, man. No, that's Advocate Mpofu, help me here, man. What's the reference?
Page 332. Don't ask me about the bundle.
It's number 12. 12. 332.
Yeah.
And we're going to paragraph 76, which would be probably further on. And maybe, Mr. Mataboge, before we get, well, while we're getting there, the concern that the Constitutional Court had and which they addressed is how the divergence between the manager's evidence on oath and the emails were resolved. It appears that the public protector simply chose the emails over the manager's oral testimony, which got disregarded. And it was said that this was inconsistent with the principles laid down by the SCA in Mail and Guardian. A decision to which the report actually referred. And that the objective, I mean, I'm waiting for you, so as you get to the page, just go there, right? So that's what they say in paragraph 76, where they say the decision affirms in Mail and Guardian the objective of investigations by the public protector is to discover the truth. When the investigation yields disparate pieces of evidence which do not fit into place, the public protector must continue digging until the two picture emerge. And then they quote Nugent, go down. Let's stop. The public protector has no place summarily dismissing any information. His or her function is to weigh the importance or otherwise of the information, and if appropriate, take steps that are necessary to determine the truth. And then it sets out what Mail and Guardian says. And here in paragraph 78, the truth which the public protector was seeking was whether the president had personally benefited from the CR17 campaign donations. She has failed to discover this. The manager's testimony was to the effect that he did not benefit personally. But even if this evidence was to be rejected, there is just no evidence that established a personal benefit. The emails on which the public protector relied simply showed that the president was more involved in the affairs of the campaign. And I've taken you to the emails. This is not the same as receiving personal benefit. And then in paragraph 79, moreover, the public protector would not disregard the evidence of the campaign managers solely on account of the emails that diverge with that evidence on the involvement of the president in the campaign's affairs. Instead, she was required to evaluate those witnesses' credibility and the reliability of the testimony on the one hand, and the authenticity and reliability of the emails. I just want to stop there. What did you do to evaluate the authenticity and reliability of the emails that was received?
I would not comment on that.
Why not? You're the chief investigator. You're the main investigator in the Busasa matter. You obtain emails from a whistleblower, and I'm asking you, what did you as the investigator?
I can't hear you, but Bauer, you're on my side, you're muted or something. I could not hear you.
No, can we in the committee?
To 8 minutes break, and then we can just grab tea in the meantime. I was not hoping for a break.
Okay,
so we're in the same space.
Yeah, no, sure. Okay. Anyway,
is he back?
It's back.
Are you back?
Thanks. I was just about to walk out.
Okay. Advocate Bauer, how far are you?
I need about another 10 minutes.
Okay.
Okay.
That's fine.
All right.
Just go ahead. So I will hold back on the break.
Thanks, Chair.
Right.
Please, Mr. Mataboge, can you hear us now?
Yes, I do now, Chairperson.
Okay, over to you, Advocate Bauer.
If the judgment can go back on the screen, I was taking you through some paragraphs in the Constitutional Court judgment, right? And I asked you, what did you do to authenticate and ascertain the reliability of the emails received from the whistleblower?
Just a pause. I just need to check that for completeness here as well. Honorable members, Honorable Diana, can you hear us? Sy is uitgevang. Sy is nie daar nie. Honorable Milam. Honorable Milam. Honorable Van Meenen.
Chair, I can hear you. Sorry about that.
Yeah, also
Can
from
you
my
hear us?
side, disappeared briefly, but you're back.
Can you hear us now?
Yes, I can.
Okay, thank you. All right, proceed, Advocate Bauer. Thank you, PP.
Mr. Mataboge, I asked, what did you do to authenticate as the investigator to confirm the authenticity and the reliability of the emails that you received and on which you relied for your findings?
I'd rather not answer that.
And I'm asking, on what basis do you not want to answer that, Mr. Mataboge? Because you were the investigator in the matter. Did you do anything? Did you personally do anything to check the authenticity and reliability of the emails?
No, I didn't.
Were you instructed at any stage to check the authenticity and reliability of the emails?
No, I wasn't.
So, okay, let's move off that. After the judgment was handed down, and I'm going to take you to, did you have any role to play? 190.36540. Did you have any role to play, Mr. Mataboge, in the decision to seek the rescission of the Constitutional Court judgment?
No, I didn't. Not at all.
Were you provided a copy of the affidavit that the public protector filed at the Constitutional Court for your input?
I don't recall. I don't recall at all.
190.36540. This is an email. Can you show where it comes from? Okay, well, I'll tell you. This is an email that Mr. Paul Ngubeni writes to you following the judgment of the Constitutional Court. And he addresses the email to the public protector and Mr. Satoli. Mr. Satoli didn't have much of a recollection of Mr. Ngubeni's involvement in matters. But you see that?
Yes, I see it.
We go down. And Mr. Ngubeni, whom Mr. Satoli's evidence was, by the way, had actually authored the opinion on which you relied and on which had come out by Mr. Sienego, writes an urgent email in which he advocates seeking the rescission of the Constitutional Court judgment on the basis that the court had gotten clause 2.3 of the Executive Ethics Code so wrong. Do you see that?
I see it out well.
Had you previously go down, Sepo? Have you previously seen this email?
I'm seeing it for the first time today.
Okay, so we'll that cuts us short. We'll take that up with the public protector, right? All right, so let's just go to this IGI report quickly. Do I understand you? And we must be very clear about this. Every reference to the Inspector General and the IGI report in the report that was finally issued was not put in by you, but it was put in by the Public Protector.
Yes.
Now, how often are you given access to a classified report in your years as a chief investigator? How often have you had a classified report in your possession or been given access to it in any way? How commonplace is it?
I've been a chief for almost 5 years. It was not commonplace, and because there's never been any classified report that came into my space, except
than
the
this one?
IGI one. Yes.
And yet, Mr. Mataboge, you couldn't remember it at all.
I could not, because there were other reports that, like I said yesterday or the other day, that I get many reports. That's why I even cited the Sikakane reports, the Mpati Commission reports. There are many reports that come through to me, yes. That's why I could not remember it.
Right. When you testified under direct, I showed you a set of notes at 189.43, and you told me that that was Ms. Mvuyane's handwriting. Do you recall that? 189.
Yes.
Right. Ms. Mvuyane's testimony was that would have been taken at the meeting at which she attended with you in the company of the Public Protector, and that she was not high up enough on the totem pole to be having meetings alone with the Public Protector. Would that be correct, that she would not be meeting alone with the Public Protector?
That would not be necessarily correct. What if when Public Protector wants her to discuss something with her, I'm not in? It would not be 100% correct.
But her evidence was that she was not meeting alone with the Public Protector in respect of this matter. It could well be that in the greater scheme of things, if the Public Protector called her directly, she would have to go. But her evidence was that in effect, when she met to get changes of the reports from the Public Protector, as in this case, well, this minute, you were present. Can you comment on that?
No comment, because I'm not sure.
Right.
I'm not
And
sure of that.
we've placed this note that she took to be 2 or 3 days prior to the report being issued. So I just want to take you down to, just go scroll down. Sorry, just go back up, go back up, go back up. We see in page 9, there's a reference to the state of capture report that's been put in. If you go down, go further down, stop there. You were asked about whether the Public Protector ever gave you an instruction to remove something from the Rule 53 record. You recall that?
Yes, I recall that question.
And that Advocate Mpofu asked you whether you were ever given an instruction from the Public Protector to remove any item from the Rule 53 record. Do you recall that?
Yes, I do.
Right. Here is an instruction from the Public Protector to remove the Jean Ravella dossier, even in the narrative. Do you see that?
Yeah, but the instruction is not to me.
No, there's an instruction that goes out. Let's assume Advocate Ms. Mvuyana says you were both. Let's take this differently. This is an instruction that is given at the meeting at which the evidence from Ms. Mvuyana is to us that you and both she and you are in attendance at that meeting. You don't know if you were there or not. Am I correct?
Yes, I'll have to confirm to be correct, but I wouldn't want to commit to something that I'm so unsure of, because even this removal to me, it's strange. I'm seeing it. I'm seeing it for the first time. Yes.
You do know that there is an issue in the judgments specifically relating to the Jean Revelle dossier that has come out. Do you recall that?
Yes.
Right. Do you remember what it was about?
Wasn't it about the HR process that led to the appointment of some members of the unit?
You see, without wanting to belabor the point, the court's criticism was that in respect of where the dossier suited the public protector's purposes relating to recruitment, reliance was being placed on it. But when it related to evidence before the Nugent inquiry by Jean Revelle, would disavow that an unlawful unit existed, that evidence was no regard was had to that evidence, and that would have been in the dossier. And that comes out in the judgment. Do you recall that?
No, I don't recall it.
I'm going to.
Chair.
Advocate Mpofu?
No, yes, no, I didn't want to interrupt my learned friend, but I think this is an unfair line of questioning. Firstly, from some cryptic notes, which I think Ms. Mkhwebane described as shorthand, and remove from what to what, and unless if Advocate Bauer knows what the cryptic note was referring to, or who was instructing whom, and so on. But the most important point is that these are questions that should have been put to the author of the shorthand notes, who was here yesterday, or the other day. And there was no issue about removing anything from the Rule 53, from what I recall.
Now, there was, Advocate Mpofu, I did raise the questions with Ms. Mbuyana in respect of this. The witness said, Mataboge said that there was never an instruction to remove it. And the next question that I'm going to ask is, are you aware that there is no reference to the Jean Revelle dossier in the Rule 53 record? Mr. Mataboge, did you hear the question?
Yes, I did.
Are you aware that there's no reference in the Rule 53 record to the Jean Revelle dossier?
Yes.
Right. And do you know that in the actual report, the SARS report, there's no reference to the Jean Revelle dossier? In the source documents, it's referred to elsewhere, but not in the source documents.
I wouldn't remember that exactly.
Okay. I understood that you accepted what one of the members put to you. The top secret security clearance didn't entitle you to access to a classified document. Did you at any stage check the law at the time?
Chairperson?
What law would come?
Just hold on, Mr. Mataboge, Advocate Mpofu.
Chairperson, that's also, that question is completely uncalled for. Firstly, I would be very wary to take the interpretation of a member, an unidentified member, on a legal interpretation and whether that's correct or not. And now we all work on that premise.
Thank you.
He accepted it, and I want to be sure that.
Well, they might be both wrong. Sorry.
No. Can I?
So can continue.
So the clarification I'm seeking from you is, Mr. Mataboge, you didn't check the law yourself at the time.
What law would come?
The law on whether the law that regulates classified documents. Essentially, it would be the
Yes, I did check it.
Did you check it?
Yes.
And did you come to the conclusion that under the MIS, you were entitled with your top security clearance to have access to any classified documents in the country?
Yes, I thought so.
Are you aware that under clause 24 of MIS, there's something called the need to know principle?
Yes.
And can you tell us what that means?
But I wouldn't. I'll have to check and find a way to phrase it. I will not just off the cuff to deal with it now or to do it.
Let me help you. Under the need to know principle, it says the furnishing of only that classified information or part thereof that will enable a person or persons to carry out his or her task. And that it isn't necessarily linked to top secret security clearance.
Yes, I follow it now.
You check the legislation that pertains to this as well, Mr. Mataboge, the Oversight Act and the Protection of Information Act.
Yes, I do as a matter of fact.
I have only one thing that I'd like you to get back to us on. You were asked this question by, I think, a member that said, did Mr. Pillay say, and I'm not sure if Advocate Mpofu asked you that's a member, did Mr. Pillay say that he was a member of the SARS unit? Do you recall that? Was it?
No, that wasn't asked to me. That wasn't asked to me at Red Power. I don't recall it.
Yeah, it was about Mr. Godan. But it was part of the establishment.
Yeah, if it was me, it was definitely not this witness. In fact, funny enough, I intended.
It was Honorable Mauto's question about the,
yes.
Mr. Godan and the establishment of. So that was the member who asked that.
Okay, so the question was, you said that, just get right, Mr. Godan. Evidence to the public protector was that he had been involved in the establishment of precisely which unit was that? I just want to get.
I asked the question to say to the member who was asking it to say he or she must clarify which unit. I did not use the word myself.
So the issue is there is the alleged SARS rogue unit, and then there's other units by other names. And so I wanted to be sure as to whether what precisely it is you were testifying, Mr. Godan had confirmed in his evidence to the public protector. And if you want an opportunity to respond to that after you go and look at the notice, then I'm happy for the chair to say, for the sake of us getting done, to do that in writing.
No, Chair, I would not want to go that far because the question was then asked by, I think, Honorable Maotwe, and I wanted her to clarify because she referred to some other name. Then I said, what name? So why would I have to go and do a written response to such a simple, short question?
Sorry, no.
Before I responded, I asked her she must clarify what unit she's referring to.
Yes, Chair, if I may assist, it looks like the question was about the establishment of the unit. The only problem is that Honorable Maotwe then said, otherwise known as the rogue unit. Then the witness said he obviously did not, because he was saying it's lawful. And then Honorable Mauto then came with a neutral term, which was, did he agree to the establishment of the SARS unit? In other words, to remove the lawful or unlawfulness.
And I understood you to have answered yes, but I want you to be exact, if you can recall precisely what it is that Minister Gordhan said he had been part of the establishment of.
Chair.
Honorable
Yeah.
Mauto, you
Yeah,
don't,
I can
you have
assist.
not raised the hand. No, Advocate Mpofu has assisted us and I agree with him. That's
I was
exactly.
the person who asked the question, Chair. I
We
can ask
know, I have
the
not
question again.
noted you. I have not noted it's done. I think it's corrected.
But it's not done because
properly.
Advocate Bawa is going back to it, Chair. That's what I'm saying. Because I'm the one who asked the question, I can ask again.
I've not asked you to do that and I've not recognized you. Please hold
I
back.
don't need you to ask me to do it. I'm saying, can I help? Can I
Please
assist? Advocate
hold
Bawa is
back,
still not
Honorable
sure.
Mauto. I have not recognized you and I've
It
not.
was the
activated your
SARS
platform.
unit, Chair. SARS
Over
unit.
to you, Advocate Bauer. Over to you, Advocate Bauer.
The Mataboge SARS unit.
Over to you, Advocate Bauer. And I'm not going to repeat that.
Chair, I think Advocate Mpofu has assisted us and the witness. And I just wanted the witness to be very clear about what he was saying yes to.
I've also assisted when I'm.
Okay. Sorry, Honorable Mauto, I want you to withdraw what you have just said. Honorable Mauto, I want you to withdraw what you have just said. Honorable Mauto, I'm addressing you. I want you to withdraw what you have just said. It's unparliamentary of what you have just done now. You know it's not done. Please unmute Honorable Mauto. Honorable Mauto, I'm addressing you. Please unmute and withdraw what you have just said. Honorable Mauto, I'm doing this for the last time. Please withdraw what you have just said. I'm going to ask ICT to assist me and remove Honorable Mauto. Thank you, ICT. Proceed, Advocate Bauer.
Chair, can you please remove me as well? I need to go to the
Last question. So, Mr. Mataboge, are you there?
I'm here, Advocate Bauer. I had muted myself.
Yeah. I just don't want what you said to be misunderstood. And I think Advocate Mpofu and myself are on the same page that we must just be clear about what you said. Minister Gordhan had indicated to the public protector that he had been part of the establishment of. And I know that he said it on affidavit during the 7-9 process and in the meeting. And that's why I offered you the opportunity to go back and to check precisely what he said to the public protector's office.
I can go and check, but I thought that I remembered him saying the establishment of the unit was lawful and that he would not, if they were involved in any illegal activities, he was not aware of them. But I could go and check. I could go and check and provide an answer. That will help.
Thank you, Mr. Mataboge, and thank you very much for assisting us. We really appreciate it.
Thank you, Advocate Bauer.
Okay, thank you, Advocate Bauer. Mr. Mataboge. We have now reached the end of our interaction with you. I would like you to, for this moment, switch on your camera.
I hope it's working fine, Chairperson.
It's not yet working. I can hear your voice, but we don't see you yet because you are going to have to be seen by us before you.
I can see myself this side, Chairperson.
Oh, now I can see you. I can see you too. I was saying, Mr. Mataboge, we have now reached the end of our interaction with you. Before I address you on behalf of the committee, I want to give you an opportunity to make any comments, final remarks to the committee.
Before remarks, I want to get off the table first.
Just repeat that.
I wanted to say after my remarks, would there still be any questions for me to
After your remarks, the only person the only person who will speak is the chairperson.
asking me questions or
no.
just making remarks?
No. I've just indicated we've reached the end of questions with you, so it is now your opportunity to have the final say.
Hey, Chairperson, the final say, I hope I don't put my foot in it, that's normally said. But as Rodney was saying, I've been through all the former public protectors, even up to Advocate Mkhwebane. From my experience, the public protector South Africa came into being was not similar to the classical ombudsman that is known globally. And as a result thereof, in my view, it gave powers to the public protector that were not there in the classical ombudsman space. And for me, in my view, that was the starting point of our problems. No matter what was well intended with those powers. That is the first point I want to comment to make. Secondly, the Nkandla judgment also added more powers to already the powers that were already there with the public protector, meaning that now it was like having a very sharp axe with which the public protector, whoever is the incumbent, would then have to cut or to chop, you know. And as a result thereof, I want to use the word that the principle that, you know, power corrupts, but it is always said that absolute power corrupts more. My view is that personally, there's just too much power centralized in the incumbent. I don't want to say Advocate Mkhwebane or Advocate Madonsela, but in my view, as having worked for this long in this institution, there's just too much power centralized in one person. And in my view, the appointment of the public protector is, for me, it's a personality appointment. It's as good as the person that is at the head. It's as weak as the person that is at the head. If the person is being seen as a good person, it will reflect throughout on his interactions or her interactions with the public or even whoever that comes into his or her space. So in my view, my little personal view is that this power that I refer to that is centralized. I know Parliament is the chairperson to be an oversight, to hold the public sector to account. But when does that happen? It happens once in a while. So I was having a brainwave the other day to say, but why doesn't the public protector have an advisory board or a council that would meet often to look into the affairs of the office of the institution and advise the public protector and from time to time? So that's why I was saying I don't want to rub anybody the wrong way, because that would then call for an amendment of the legislation that gave all these powers to the public protector, as well as then bringing this advisory board or council or commission into a space. I'm saying this because with due respect, the management that is within the public protector doesn't assist him much or him much in the day-to-day or in the affairs, as it's an example of what brought us here today. they don't have much really. And maybe it's because either they are partisan or they are afraid, they don't want to be seen to be challenged. And sometimes even the public, maybe the incumbent or the former incumbent would not be not amenable to what they are suggesting. But some of them, they are just partisan and they follow instructions. And in my view, that doesn't work well for the institution. So I think that's a bit that I could close on my involvement and my engagement with the process today, Chairperson. Thank you.
Thank you very much for those comments and your final words to us as the committee. We will definitely take those to heart and attend as part of the work that we do. On behalf of the committee, I want to thank you for availing yourself. Before you came last week, and as well as yesterday and today, including coming on a short notice, the committee really appreciates that commitment and availability from you and your contributions. We hope that we'll be able to utilize them in our deliberations, and hopefully they will be useful to the findings and the recommendations of this committee. And your final remarks already, and I was taking notes, giving us homework beyond the inquiry, because it is about the institution. I appreciate that because we are in that space. Thank you very much. With that, you are now officially excused. And I'm going to ask you so that before anybody else has a question, you switch off and leave the platform officially.
Thank you so much, Chairperson. I'm out of here.
Thank you.
Chair.
Thank you very much, colleagues. So that we don't waste any time. Tea has been waiting for us. I'm sure we can grab that as we go. So I'm going to, I promised Advocate Mpofu, who should be on his way, that there's something he wanted to address the chair and the committee about, and I'm sure he'll be brief in doing that.
Yes, thank you, Chair.
Over to you, Advocate Mpofu.
Thank you, Chair. Well, because you know that I'm in a rush, I think it's an indirect way of muting me.
You're not muted at all.
So, no, Chair, I want to address, you remember yesterday there were issues that I wanted to raise when we were addressing Advocate Matonsela, which were like the non-Matonsela issues. So they are not as pressing as the reason why I have to go now. So the only issue I needed to raise, Chair, is and apologize for having not met your deadline of 1 o'clock. We owed you a response on the proposal that was received by us overnight regarding the evidence of Advocate Matonsela. We will still send you something in writing, but I just wanted formally to say on the record that we accept the proposal as it was made to us, just so that the systems can start functioning. In other words, we will see you on Monday. Thank you, Chair.
Thank you, Advocate Mpofu. That proposal, therefore, is now giving the baton over to me. That proposal, we're speaking in codes here now, means that you have a day off tomorrow, but we're back on Monday and Tuesday to conclude Advocate Matonsela. So on that note, let's adjourn our meeting, take tea, and see each other on Monday.
Thank you, Chair. Amandla.
Yes. Honorable Gonda, before I close. Honorable Gonda.
Thank you, Chair. Chair, I'm confused now. What do you mean we're going to conclude, Advocate Madonsela?
Come again?
You said on Monday and Tuesday, what are we going to do?
Okay, I'll assist you. You wanted to say something?
Sorry, Chair, but that wasn't related. Maybe you want to. take
No,
it.
yeah, thank you. No, just a clarity to members. And I'm sure Ted Mugos will be sending that to you. As a chair on behalf of all of you, yesterday we wrote a letter clarifying a lot of the issues of yesterday. And as part of that letter, we then went back and say to them, we're still offering Monday and Tuesday, as we discussed yesterday. And that's a proposal that Advocate Mbofu is saying that they will be taking that up on Monday, and they will lead Advocate Madonsela, and then we conclude that. Sure. Thank you. Happy Advocate, your Honorable Konde. That's fine. You don't have to respond. Thank you.
Let me respond. I'm still very confused, but I take the lead from you as a chairperson. It's fine.
Assist you, no problem. Thank you. Honorable members, they will see you on Monday, and there's going to be a correspondence coming your way. On that note, I want to avoid this any other business.
No, but
I will hear you out.
It's directly linked to that, Chair. We had an arrangement that the public protector's statement would be due on Tuesday. Now we're having Professor Madonsela Monday, Tuesday. We need some clarity as to how that happens there.
No, remember when yesterday, when I addressed this meeting, we said there were scenarios. And I put all of those scenarios. They started from Saturday and Sunday, and that could not stand. And then they went to Monday and Tuesday. And the Monday, Tuesday scenario then said, that scenario means we shift the date of the statement to the 9th. Okay? So that was addressed here yesterday. If there are difficulties that can be attended, but that's part of that proposal. Chair, I hope that assists Advocate Bauer.
Yes.
No,
Chair, I
I'm
think the
confirming
chair,
on his behalf.
yes. I think the chair is right.
There's an official letter in that regard.
It's in the letter.
Yeah.
Yes, it's in the letter. There's even something about installments, but I think we can deal with that in the back room. I think the most important thing now is when are we coming back?
Yeah. Now that you've deposited this issue here, and you can just a paragraph just formalize that would help.
We'll do that.
Okay. Thank you. The meeting is adjourned. Thank you.
Thank you.
Recording stopped.